appeal in the matter of Optis Cellular Technology LLC and others, and Apple Retail UK Ltd and others.
Good morning. First of all, if I could tell you that you can take it that we have read extensively and we hope that we've understood the issues, and therefore you can take it speedily to begin with, at least. And also that we think that 2.5 days is a very ample time estimate, and therefore you shouldn't feel that you had to feel every second, put it that way. And also, we thank you for beginning at 10. I hope that hasn't been too inconvenient for you, and that if necessary we will sit for a little bit of extra time at 1 o'clock, although of course we don't, it's a long day to be in court, and we don't want to pressure to people too much, but I think that would be a sensible thing to get on with this. So with that in mind, please begin.
My lady, thank you for those indications. You'll have seen that I appear with Mr. Pickford, KC, Miss Love and Mrs. Septu, and for Optis are Miss Ford, KC, Miss Jamal, Miss Mackenzie and Miss Dixon. In terms of timing, I respectfully agree with your ladyship's indication that there is ample time. We have provisionally divided the time between us, but I don't think that we, especially in light of your indications, need take up the whole time.
No.
Just to indicate so that you're aware, I'm making all the submissions on our side. For Optis, Miss Jamal is making the submissions on grounds 1, 2 and 4, and Miss Ford on ground 3.
Thank you.
May it please the court, this is Apple's appeal against the judgment of Mr. Justice Meade in Trial F, as you know, took place in July 2021. And as you also know, the hearing as to the terms of a FRAND licence took place in the summer term of this year before Mr. Justice Marcus Smith, and judgment is awaited. Trial F, as the court has seen, was ordered in order to determine Optis's allegation that it should be granted an immediate and unqualified injunction in respect of its valid and infringed SEPs, removing forever Apple's right to a licence on FRAND terms under Optis's Etsy undertaking before any determination of those FRAND terms. And Optis justified this on the basis that it had said it had made an offer to provide a licence on whatever terms the court finds to be FRAND following the FRAND trial, Trial E, and that Apple had not committed unconditionally to enter into that court-determined licence prior to its determination. And Optis's essential argument was and remains that this fact takes Apple outside the class of beneficiaries of its Etsy undertaking on a proper construction of Clause 6.1. As the court is aware, Mr. Justice Meade rejected Optis's case that it was entitled to an unqualified injunction, and his decision in that regard is the subject of Optis's cross-appeal. However, the judge held that by declining to commit unconditionally to a court-determined licence, once an asserted SEP had been found to be valid and infringed, Apple fell for the time being outside the category of beneficiaries of the Etsy undertaking. And so the judge accordingly held that the appropriate form of injunction was a FRAND injunction of the type ordered by Mr. Justice Burse in the Unwind Planet Remedies judgment. In other words, an injunction that would cease to have effect upon Apple actually entering into a licence covering the relevant patents. And as you'll have seen from our ground 4, that isn't actually a remedy that Optis had sought. Now, an important feature of the judge's decision was that the injunction he ordered was a final injunction, not an interim injunction, pending FRAND trial. And of course, the judge's ruling is not confined to the present case, but is of general application, given that it follows, in his view, from a proper construction of the Etsy IPR policy. And the practical consequence of it is that an implementer in Apple's position must, in order to avoid an injunction in the UK, commit to take a global portfolio licence without knowing its terms. And in view of the court's indications as to your extensive pre-reading, what I'd like to do before turning to the detail of my submissions on each of our grounds of appeal is really try to get to the heart of the issue by summarising the 4 key points that we say arise. So the first point relates to the assumptions against which Trial F was determined. and the court will have seen that certain issues between the parties which were relevant to the issues of trial A were set down for trial at trial E. And Mr. Justice Meade proceeded correctly, and this is common ground, on the basis that those issues would be determined in Apple's favour at trial E. So those allegations were assumed in Apple's favour. And one of those assumptions is that the licence offer that Apple made to Optis for its global portfolio before Optis launched litigation was a frowned offer. And we say that that is highly relevant to the question of the proper construction of clause 6.1 of the XCIPR policy. Because Mr. Justice Meade, just standing back, found that Apple was not seeking a licence within the meaning of clause 6.1, was not a willing licensee, to put it a different way, even though it must be assumed to have made a frowned offer for a global portfolio licence. And we ask, we ask rhetorically, how can it be right? How can Apple not be seeking a licence when it has offered frowned terms for that licence? Because if Optis had accepted those frowned terms, there would now be a frowned global licence. Indeed, it's entirely possible that the court following trial E might fix frowned terms that are identical to those proposed by Apple. They're frowned terms after all. It's got to be assumed they're frowned terms, so the court might arrive at the same terms. And the licence, if that happened, the licence entered into by the parties would be the same licence that Apple offered before Optis rushed off to court. And we say in those circumstances, how can it be said that Apple is not a willing licensee? Not only did Apple make a frowned offer, it must be assumed, but it has engaged in expensive litigation with the very aim that the court determines frowned terms for a global licence. And Apple wishes to take such a licence, and the overwhelming likelihood is that it will take that licence. And what this case is really about is the very small possibility that the licence terms set by the court are so onerous as to be commercially unviable or unacceptable. And it's to guard against that small risk that Apple did not wish to commit to take the court-determined licence for this global portfolio licence without first seeing its terms. So to put it colloquially, Apple doesn't want to be in the commercial position of signing a blank cheque.
So the proposition is that Apple is guarding against the risk that the court will set licence terms that are so onerous that they will be commercially unviable or unacceptable.
That's right. And my lord...
So Apple is protecting itself against a future court decision adverse to it.
My lord, that's correct. And of course, in a sense, the point is perhaps obscured by the fact that the litigant is Apple before the court, because one can imagine a position where you have a much weaker entity in the market who perhaps does a very small proportion of its business in the UK and is indeed deciding whether or not to enter the UK market or to continue operating in the UK market. And the precise terms of the licence may be highly relevant to the question whether it does.
Can you answer me this question? If there is an adverse court decision against Apple, why is Apple's remedy not to appeal?
My lord, it may appeal, and of course...
So what you're supposing, the logic of your argument, is that you're going to lose the appeal.
My lord...
So suppose you go all the way to the Supreme Court.
Yes.
So you are guarding yourself against the risk that the Supreme Court will determine licence terms that are, to use your words, uncommercial or unviable.
My lord, that's right. And so, and one doesn't need to go so far as to say unviable, because they may just be uncommercial. And the reason why we say that makes sense is because, as you know, the Court of Appeal in Unwired Planet rejected Mr. Justice Burse's conclusion that there are one set of frowned terms, and frowned is a range, and there may be different approaches to deciding where in the range the terms are. And the range may be very wide, and it may be that terms are frowned and so are not impugnable on appeal because they're frowned, but they're still commercially not the right thing to do. And so that is the risk. It may become
Doesn't that mean, though, that therefore FRAND, the way that you're describing it, that FRAND actually becomes solely something which is negotiated between the parties?
My lady, no, because we do make the converse point in this case, and I'm going to come to it, which is that the approach of the judge below would effectively result in negotiations being bypassed. So we do say that negotiations are a very important part of the piece, but we don't say that our case would result in the court not having a role, because as we say, the overwhelming likelihood is that once a party's participated in a FRAND trial and shown that its intention is to take a FRAND licence, the overwhelming likelihood is that it will take that licence. So the court will perform a very important role. But the point is that it's extremely rare in a commercial context to sign terms which are extremely onerous. In this case, we're talking about global portfolio licences, and the amounts claimed by Optis in the negotiations runs to billions. So it's commercially not the normal course, if I can put it that way, to commit to terms without knowing what they are.
This is your blank check argument.
It's the blank check argument.
Mm-hmm.
I'm going to explain it in a little more detail. But what we say is, I'm making a more confined point at the moment. So we say that guarding against this small possibility doesn't make Apple an unwilling licensee. And if I could just ask you to turn up the judgment, just to make one point at this stage. So Core Bundle, tab 13, page 183. And it's paragraph 290 of the judgment. And the learned judge there is addressing our argument that Apple had made a FRAND offer and wants a license. So really the same submission that I've just made to you. And the judge says the trouble with the submission is that Apple only wants a license and is only willing in a limited sense. Its offer within the FRAND range does put it in a different situation from that of Huawei in the unwired litigation. Just pausing there, well, of course it does, because Huawei in the unwired litigation was up to and including in trial, saying that a global portfolio licence was not FRAND and was anti-competitive, but falls critically short of agreeing to take a licence on the point within the FRAND range that the court settles at Trial E. It only wants a licence on its own terms and at a time of its choosing, and then only conditionally. It reserves the right to say no altogether. And we say about that there are two errors in the court's reasoning here. The first is that the court has proceeded, in effect, on the basis that there is that there's only one way in this context for an implementer to show that it's willing, that it's a beneficiary of the Clause 6.1 ETSI undertaking, namely to commit to take a court-determined licence, and we say that's wrong. And if we could just open up, in this context, Unwired Planet at first instance, so that's in joint authorities. You can put the judgment away for now. So, joint authorities, tab 13, page 441. And it's paragraph 693 at the top of the page. So it's tab 13, page 441 of the bundle. Paragraph 693. And Mr. Justice Burr said there, an alleged infringer who wishes to show that they're a willing licensee could do well to make an open offer of the FRAND terms it would be prepared to accept. I don't say that that's a mandatory requirement, and neither does Huawei and ZTE. So we say that there, Mr. Justice Burr, as he then was, correctly proceeded on the basis that there is no single way for an implementer to demonstrate that they're willing. But he says that an implementer which does make an offer in the FRAND range is willing, or at least goes a long way to demonstrating that they're willing. The second flaw in the passage of the judgment that I showed you is that in saying that Apple only wants a license on its own terms and at a time of its own choosing, in saying that, the judge made an error because there's no basis for this finding. It's not right that Apple only wants a license on its own terms and at a time of its own choosing. That conclusion certainly can't be drawn from the fact that Apple has refused to commit up front to the court-determined license before seeing its terms. Because Apple isn't saying, well, we've made a FRAND offer and that's the only license that we're prepared to conclude. If it were saying that, it wouldn't have engaged in the FRAND litigation to determine license terms. It recognises that those terms may be different to the terms it's offered, and it's prepared to accept terms other than those it's proposed. It just wants to see them first. The other reason that we say, a further reason that we say that the judge is wrong in that paragraph, is that he failed to take account of how the parties got to the position that they did. And this is where Apple's competition law allegations are relevant. And so perhaps could we pick up the judgment again? So core bundle, tab 13, this time page 123. And the allegations, the competition law allegations, are summarised by the judge in paragraph 60 of the judgment. So in summary, Apple has alleged that Optis has never made an offer which is FRAND, only made offers which are so far in excess of FRAND that they disrupted negotiations, and abused its dominant position thereby, and by seeking the relief that it does at this trial, with the objective of getting royalty rates far in excess of FRAND. So that is all assumed in Apple's favour, correctly. But we say that having held correctly, and you see this at paragraph 63, that those matters must be assumed in Apple's favour, what in fact the judge did was to ignore them when determining the question whether Apple is a beneficiary of Optis' Etsy undertaking. Because had Optis not committed these abuses, then there would have been a constructive negotiation. The very purpose of its abuses was to disrupt the negotiation with the aim of achieving royalty rates far in excess of FRAND. That's the allegation that needs to be assumed. And so, had that not happened, had those abuses not been committed, there would have been a constructive negotiation. Optis would have responded to Apple's FRAND offer, presumably with a FRAND counteroffer, and the parties may well have reached agreement. And there couldn't have been any doubt in those circumstances that Apple was a beneficiary of Optis' Etsy undertaking. So in other words, if you freeze the position at that point and imagine no abuse, Apple's made a FRAND offer, well, plainly that's showing that it's willing, and Optis engages without abusing its dominant position in the negotiations constructively, and there's the normal to and fro in negotiations. Well, it can't be said in those circumstances that Apple is not a willing licensee. And we say that the only reason now why Mr. Justice Meade has found Apple not to be a willing licensee is because of the abuses that have to be assumed against Optis. So the negotiation wasn't constructive. Optis, against the backdrop of attempting to disrupt the negotiations, proceeded to court to gain an injunction, claiming an injunction. And it's in those circumstances that this point has arisen. So Apple's failure to commit in advance to the terms of a licence before seeing them is said to render it unwilling, but that's all been brought about by the alleged abuses. So we say in those circumstances too, it was wrong for the judge to characterise Apple as not seeking a licence, as an unwilling licensee. And now a further point which is highlighted by the competition law allegations relates to the importance of negotiations. And I'm going to come on in more detail to deal with this under my submissions for grounds 1 and 2. But as I'll show you, both the Etsy framework itself and competition law proceed on the basis that there will be an effective negotiation between the parties. That's what's encouraged. And of course, you've just seen that the competition law allegations, which need to be assumed in Apple's favour in this case, include an allegation that Optis deliberately disrupted the negotiations by making very inflated offers and then proceeded straight to litigation. Now, the judge's construction of clause 6.1 needs to be robust to all factual circumstances, including to that context, because of course he's construing clause 6.1 in general. So it needs to be robust to these factual circumstances too. And if it were the case that a SEP owner could disrupt negotiations on purpose and then bring a claim for an injunction and be awarded an injunction if the implementer failed to agree to commit to a global licence in advance of seeing whatever global terms the court sets, this would seriously undermine the negotiation process. Indeed, we say it would mean that negotiations could be bypassed altogether. And that's a key reason why we say that that can't be the correct interpretation of clause 6.1. So that's really the first key point that I wanted to address. The second key point that I'd like to address at the outset concerns the question of jurisdiction or extraterritoriality. And we say that the implications of Mr. Justice Meade's judgment has implications for the delicate jurisdictional balance that our courts have drawn in this area. Now, of course, it's common ground and it's trite to say that the UK courts have jurisdiction to enforce UK patents only and not to enforce foreign patents. So that's the starting point. But it's been established in the Unwired Planet litigation that our courts have jurisdiction to determine FRAN terms for global licenses on the basis that this is what an implementer needs to pay to use a UK patent. And that necessarily entails setting royalties for use of foreign patents. But the reason why that's justifiable in a nutshell is because licenses for portfolios of SEPs in this industry are generally concluded at a global portfolio basis. That's what the court has held to be FRAND. But what we have is the court steering a delicate course in terms of their jurisdictional limits. And as the court's aware, this was all ventilated in the Unwired Planet litigation, which really forms the starting point. And we say that what Optis are seeking to do, the effect of its argument, is really to leverage this situation, and the outcome is to disrupt the jurisdictional balance. And I'd like to just explain briefly by reference to some hypothetical examples why that's so. So I'd ask you first to take an example, a hypothetical example, of an implementer who practices only UK SEPs and operates only in the UK. And the SEP owner seeks a UK portfolio licence, and in the context of that case, a UK portfolio licence is FRAND, and proceeds straight to court. So the SEP owner proceeds straight to court, claiming an injunction should the implementer not commit in advance to whatever terms the court sets for the UK portfolio licence. And on the basis of Mr. Justice Meade's judgment, the implementer then provides that commitment. So let's say we're unsuccessful on this appeal and Mr. Justice Meade's judgment construction of clause 6.1 stands. So on the basis of the law as it is, the implementer says, oh, well, all right, I'll provide that commitment because otherwise I'm going to be injuncted. The court then sets licence terms which are commercially not acceptable or not rational for the company concerned. So they're FRAND, but they're at the high end of FRAND. And it's key here that that terms might be FRAND, but just might not be commercially rational for a company to accept, even though they're FRAND objectively, depending on the position, for example, of the company concerned. Now, the implementer has to enter into the licence because it's undertaken to do so. So it's got to take the licence because it's given the undertaking. However, the upshot is that it still has a commercial choice after the court has set the licence and after it's taken the licence, because it could decide not to practice the UK patents anymore, for example, by changing its business or simply withdrawing from the market. In which case it wouldn't have to pay the commercially unviable royalty. So the licence would be in place, but essentially there would be no royalty because it was no longer practicing the patents. So that's a commercial choice that that company could make if it were a company just operating in the UK, just practicing patent SEPs, UK SEPs. But by contrast, the effect of the judgment below is that a global operator such as Apple enjoys no such choice. So assume that the court in this case sets terms that would be commercially unacceptable for Apple or any global operator in Apple's position. Now, having committed to take that license, Apple, of course, has to take it, has to honour its commitment, its undertaking. But it can't do, as the UK-only operator could do, it can't avoid making any payments. Because if Apple did decide to stop practicing the UK patents, its position wouldn't be improved. Because yes, it wouldn't have to pay royalties for the UK patents, but it would be required still to comply with the global licence terms for the rest of the world.
It would be out of the market. It would be its only alternative.
It would have to be out of the whole market.
Exactly, out of the whole market.
Exactly, my lady. And what we say, the essential point is that it's not the role of the English courts to decide whether or not an implementer practices its foreign patents. So the ramifications of this there are extraterritorial implications, which do, we say, result in overreach by the English courts. Imagine alternatively, just to continue my thought experiment, because it's my last hypothetical example, imagine alternatively a small Asian manufacturer which does 99% of its business in Asia, but which has very recently broken into the UK market. And the SEP owner sues them in the English courts, not in, say, Korea, where most of its business is done, and seeks an injunction and the determination of global FRAN terms. Now, the implementer ought to have a choice. It ought to be able to choose between submitting to an injunction in the UK or paying the global FRAN terms that are on offer. But on the basis of the judgment below, the manufacturer will have to make that choice without the critical information, knowledge of the global licence terms, because there are no licence terms yet on offer. Those are still to be determined by the court. And if the company makes the commitment and the terms set by the court are unviable for it, it wouldn't be able to avoid those terms by exiting the UK market and focusing its business in Asia. It would, as my lady's indicated, have to exit its business altogether. Now, imagine also that the same Asian manufacturer has, in the course of negotiations, made a FRAND offer for the global licence. And the SEP owner doesn't much like it, because it thinks if it goes to court, it could get FRAND terms which are much higher up in the range. And it brings a claim for an injunction. Now, the manufacturer is concerned to avoid the risk that the English court will set terms which are uncommercial for it, and so doesn't give a commitment in advance to take the licence the court sets, because it wants to see the terms first. So the manufacturer therefore decides to submit to the injunction once there's been a finding of infringement and leave the United Kingdom. Well, the court might well have determined terms that were commercially acceptable to the manufacturer. Indeed, we say that is the overwhelming likelihood. Indeed, it might even have determined the same royalty that the manufacturer itself offered, but the consequences of the SEP owner requiring the commitment is that the manufacturer has left the UK in circumstances where it would not have done so, it wouldn't have needed to have done so, had the SEP owner not imposed this requirement and the manufacturer been able to see the terms of the licence. And so we say that the consequence, for those reasons, of Optis's argument is in effect really to turbocharge the limited extraterritorial jurisdiction that the courts have carefully assumed in settling global licence terms. And we say that it results in overreach by the English courts. Now, the third point I'd like to emphasise at the outset relates to the judge's rationale for interpreting clause 6.1 as he did. The judge was concerned, as you've seen from the judgment, about the possibility of holdout. And the point I'd like to make at this stage is that it's important to be clear about precisely what that means in the present context, because holdout can mean different things in different contexts. Now, the first point is that once the parties were before the court, there was no risk of holdout in the sense of unjustified delays, in the sense of Apple dragging its heels, because the court was in control of the procedure. So the holdout that the judge was concerned with here was very specific. It was the risk that an implementer might get to the end of the Fran trial, look at the terms, say, well, I don't like those terms, and walk away. And the judge was concerned that the SEP owner would then have to chase the implementer around the world, suing in different jurisdictions, in order for global terms to be determined. And we see this, just turning back, if you've still got the judgment open, we see this from paragraph 12, so that's Core Bundle 13, page 115. And we see the judge say, trial E is as matters stand, the only way by which a global FRAND rate for the portfolio can be set by a court anywhere in the world. I asked counsel for Apple a number of times what other option there might be for bringing the global dispute between the parties to a resolution. So he says that this is the only way to set the global terms. And then elsewhere in the judgment, I'll come back to this, he's concerned that if the court doesn't set the judgment, the FRAND terms, then, and the implementer walks away at the end of the FRAND trial, the SEP owner will then have to go to another jurisdiction and potentially to multiple other jurisdictions to achieve the global license terms. So that's the starting point. That's the specific type of holdout that the judge was concerned about, which informed his interpretation of clause 6.1. Now, pausing there, it's important also to identify that the risk the judge was concerned about is a risk which relates specifically and solely to the period of time between finding of infringement by the court and the setting of the FRAND terms. And that's a really important point in this appeal. So it's a specific type of holdout, and it's limited to that period of time.
Between finding the infringement and
setting the court setting the FRAND terms, where those are done separately.
It's not just the setting of the FRAND terms, the reasons we touched on earlier. On the logic of your argument, this is the setting of the final of the FRAND terms and any appeal therefrom becoming final in the sense that no further appeal is possible.
My lord, that's a fair point. I accept that. So assume, just to make good my point, assume for a moment that the infringement issue and the FRAND terms were determined at one and the same trial. In those circumstances, the implementer would indeed be able to choose between submitting to an injunction and taking the licence set by the court in knowledge of those licence terms. And so, if the trials were held at the same time, then the mischief identified by the judge would be possible, because the implementer would be able to look at the licence terms and say, well, these are uncommercial for us. We don't really fancy appealing because we don't think that we're going to do any better. And so we're going to submit to an injunction in the United Kingdom instead. So they would be able to make that choice. And if the implementer submitted to an injunction in the United Kingdom, the parties would then have to find an alternative means of setting the licence terms for the rest of the world. At that stage, that clearly would not be the business of the UK courts. So as I say, the mischief or risk that Mr. Justice Meade was concerned about can only concern this period of time between the finding of infringement and the FRAND trial. And just to come back to my Lord's point about any appeals, so we do accept that. But by parity of reasoning, of course, there may be an infringement, as there was in one of the infringement trials here, where the finding of validity and infringement is overturned on appeal, and so that also might result in the time frame shifting. So it must follow, given that this is the specific and time-limited risk that the judge is concerned about, that the only reason this issue of a commitment in advance to take a court-determined licence arises is because of the particular way in which the English courts organise their procedure. And generally, as you know, the practice has been, generally, not always, has been for technical trials to be held first and the FRAND trial to be held later. Were the trials held at the same time, or were the FRAND trial held first, with the licence, for example, not to take effect until there had been a finding of infringement, the particular holdout risk the judge wanted to guard against would not arise at all. And one of the key points that we make is that what Mr. Justice Meade did in interpreting clause 6.1 as he did was to seek to protect the SEP owner for that precise period of time that arises because of the way that the UK courts, the English courts, organise their procedure. And we say, first of all, that that's, in a sense, the coach driving the horse, because this needs to be an interpretation of clause 6.1, which applies, as the judge himself recognised elsewhere, applies everywhere internationally, regardless of the facts. And we say that it was, though he recognised the point and sought to confront it, we say he didn't actually confront it. I'll come back to his precise reasoning. And his interpretation was driven by this particular problem that is perceived to arise because of the way the English courts organise their procedure. But what we say to that also is, if the risk to the SEP owner for that period of time really is a problem, there are other tools at the court's disposal which don't involve reading a hard-edged requirement into clause 6.1, because just as the issue only arises because of case management decisions, equally it can be addressed through case management. And so, for example, in this case, Optis could, for example, have asked for the Fran trial to take place first, and there would have been a debate about that. They could have said, well, we need it to take place first because we're very concerned about holdout in the circumstances of this case, and we're worried that if it takes place later, we'll have gone to all of this expense and Apple will simply walk away. And the court could have assessed whether or not that was a real risk. Did
your side ever propose that Fran be tried first?
No, we didn't propose, my lord, that Fran be tried first, but that, with respect, isn't a compelling point in the circumstances of this case. And the reason why it's not a compelling point in the circumstances of this case is because, in fact, the parties had, the case management decisions as to the sequencing of the trial were all made by Mr. Justice Morgan in February 2020. And Optis only came up with this argument later and only sought for trial F, for this particular point to be determined in advance. It amended its case to introduce this point after the case management decisions had been taken. So really, it's Optis's delay in raising the point which meant that the point wasn't considered at the case management stage. Now, we say that the simple refusal, relatedly, the simple refusal of an implementer to sign up to global license terms without seeing them cannot mean that, it does not necessarily mean, let me put it that way, does not necessarily mean that an implementer is holding out. And again, that's something that the judge recognised. He recognised that the fact an implementer might not want to sign the blank cheque does not mean that they're holding out of itself. And that makes complete logical sense because, as I've said, a reluctance to sign a blank cheque in that way is the commercially rational course. However, the judge's construction of clause 6.1, by requiring a commitment in all cases and without reference to the relevant facts of the case, assumes that a refusal to give the commitment always equates to hold out. And we say that that really gets to the nub of where the court went wrong. So the judge found, and we don't dispute this, the judge found that where an implementer doesn't commit in advance to take a court-determined licence, that could be an indication of holdout. And we say, of course, it's not in this case, but it could be. And he was concerned about that. And so the way that he addressed it was through interpreting clause 6.1, so as to narrow the scope of the category of beneficiaries. And we say, and I'll come on to say very shortly when I turn to my submissions in a little bit more detail on grounds 1 and 2, that reading such a specific obligation into clause 6.1 is inconsistent with its language. But we also say, and this is an important point, that there is already a mechanism in clause 6.1 for addressing circumstances where an implementer is on the facts holding out. And that is the French law principle of good faith, which underpins the contract. And so if it's the case that an implementer is not acting in good faith because they're trying to give the SEP owner the runaround to avoid paying royalties, then then on appropriate facts, the court might well find that they fall outside the category of beneficiaries of the ETSI undertaking by applying the principle of good faith. They're not acting in good faith, therefore they're not seeking a licence and they're not entitled to enforce the ETSI undertaking. And that's the way that on its face, clause 6.1 addresses the problem. And it has the benefit of being a tool which allows a fact-sensitive approach to be adopted by the courts. But what the judge did, by contrast, was adopt a construction, a one-size-fits-all approach, which results, on his construction, in the implementer having, in all cases where the SEP owner goes to court, regardless of what's happened before, and seeks an injunction, says, well, we'll give you a licence on the terms set by the court, requires in all cases the implementer to commit to that in advance, even though the particular mischief he was guarding against is very much a UK-specific issue that arises from case management decisions, and even though it may well be, on the facts of the case, that the implementer is not seeking to hold out at all and that the risk of walking away is tiny. Now, Optis says, and we don't need to turn it up now, this is paragraph 11 of its skeleton argument, that underlying our grounds 1 and 2 is what they call in their skeleton as tacit submission that holdout is never a problem and need not be considered. And that is wrong. We do not submit that, but we do say that holdout certainly can't be assumed and that a fact-sensitive approach needs to be adopted in every case, and that the judge's construction does not allow that to happen. Now, the final point I wish to emphasise at the outset, and I can take this briefly, relates to the status of the patent that has been found to be infringed, which is, of course, a standard essential patent. And the fact that a patent, as the court will be very well aware, the fact that a patent is a standard essential patent, that fact places constraints on the freedom of the patentee to claim an injunction, the circumstances in which they can claim an injunction. And another central theme of our appeal is that the judge failed properly to recognise this. It's perhaps most apparent in paragraph 288 of his judgment. Perhaps let's just turn that up now. So it's core bundle, tab 13, page 183. And here he says, it's really the first part of the paragraph that I'll just emphasise for these purposes. He says that he thinks there's a simpler way to look at matters. As matters stand, Apple is infringing Optis's patent rights. It therefore needs a licence now if it's not to be acting unlawfully. And we say that that, with respect, does not take account of the special position of SEPs and the constraints.
But why does he not do that in the immediately following sentence? So even if clause 6.1 has no limitation at all to its beneficiaries, as Apple contends, and Apple is able to call for and take a FRAND licence whenever it wants, it needs to do so now. So he is explicitly recognising the limitations on the SEP owner by virtue of clause 6.1.
Well, with respect, my lord, we say he's not, because the constraints on the SEP owner include constraints as to how, these are points I'll develop when I come to my grounds 1 and 2, but include constraints about what the SEP owner needs to do before seeking injunctive relief. And what he's saying, his starting point is to take the vanilla patent position, if I can put it that way. So a patent is being infringed, therefore a licence is required now, at this moment. And he says, well, the way to resolve that is to call for a licence now. But we say that's wrong. There is no licence available now. There are no terms of a licence. So it's wrong to say, he's starting from the position of ordinary patent law. And he says, well, the way to give effect to it in this context is to call for a licence now. But the reality of the position is that there is no licence available now, because there are no terms on the table now. No licence has been offered by the SEP owner during the course of the negotiations. They haven't complied with any of the things they are supposed to do, qua SEP owner. And so we say for that reason, he's not taking account of the context. Perhaps the best way of addressing this submission is to really now turn to some of the texts and I want to look first of all at clause 6.1 and other relevant parts of the IPR policy and the ETSI guide, as well as to what the Supreme Court said in Unwired Planet about the policy. Then I was going to take the court, just to foreshadow where I'm going, then I was going to take the court to Huawei and ZTE, which considers the constraints that arise because the patent is a set, and also take the court back to the Supreme Court's judgment in Unwired Planet, which looks at Huawei and ZTE. And then I was going to distill for the court our submissions, many of which I've now traversed, but I'll try and do it briefly, on grounds 1 and 2 together, and then grounds 3 and 4, if that's an acceptable way forward.
That's fine. Let's look at clause 6.
Clause 6 is in the supplementary bundle. Behind tab 14. And it's at the bottom of page 158, the first page behind that tab. Now, I know the court is familiar with clause 6.1. Can you just cast your eyes over it again? I'm not going to seem superfluous for me to read it out. You'll see that there are two irrevocables. One is the undertaking that the SEP owner has to give is irrevocable, and the second is the license, the FRAND license is irrevocable. And just pausing there, we say that Optis's case on its cross appeal is inconsistent with the first irrevocable, because it's saying on its cross appeal, Mr. Justice Meade in fact got it wrong. He didn't go far enough, because what he should have done is permanently exclude Apple from being able to enforce the ETSI undertaking. And we say, well, that's flatly contradicted by the wording of clause 6.1. And then we can see from the last sentence of that paragraph, before you get to 6.1 bis, the above undertaking may be subject to the condition that those who seek licenses agree to reciprocate. And what the judge found at paragraph 256, perhaps let's just turn that up so you can see it in this context. If you could also keep that open, and if you could also bear to open the judgment at the same time, so you've got two files open. And it's page 177 behind tab 13. Paragraph 256. So he's there referring at 255 to those final words. And then he says that's of some significance. It explicitly introduces the concept of a category of persons, those who seek licenses. As a matter of semantics, the concept is only introduced near the end when addressing the sub-issue of the SEP owner being able to insist on cross-licensing. But as a matter of substance, I think the concept is relevant to the whole clause. The concept defines the people who may get licenses under the SEP owner's undertaking and hence beneficiaries of the stipulation protocol. So he's there saying, all right, those words are at the end and in a specific context, but they really define the category of beneficiaries, and we're content to accept that. We think that's right. But the point to note when looking at clause 6.1 is that apart from that reference in that context to those who seek licenses, this is a clause which is directed to imposing obligations on the SEP owner, not on the implementer. So in referring to those who seek licenses, the provision is explaining who benefits from the obligations imposed on the SEP owner, but the provision places no specific obligation on implementers, and that's a point that I'll come on to make on construction. Now, turning back a page to page 158, still on ETSI, we see the policy objectives, and I'm sure that you've looked at these a number of times, or I know that you will have done. And you can see clauses 3.1 and 3.2, and they seek to achieve, the courts have held, and we agree, seek to achieve a balance between ensuring that these standards are are implemented and are used, and avoiding hold-up, avoiding a position where a SEP owner leverages their position to gain unfairly high royalty rates or prevent standards being worked. 3.1 and 3.2, which refers to adequate and fair reward to IPR holders, that seeks to protect the rights of IPR holders. And so there's a balance between these two objectives. And we'll come on to see what the Supreme Court said about that. Again, I'm sure you're familiar with that, so I can take it pretty quickly. But before we leave this bundle, if we look at the immediately prior tab, that's the guide on intellectual property rights, so the ETSI guide. And if I could just ask you to turn to page 153 of the bundle. And it's I just want to emphasise the two provisions at the top, so 4.3 and 4.4. 4.3 concerns dispute resolution, and so ETSI members should attempt to resolve any dispute related to the application of the IPR policy bilaterally in a friendly manner. And then 4.4 shows that what's envisaged is that a negotiation will take place. So it concerns non-disclosure agreements. It said to recognise that those may be used to protect the commercial interests of both sides during an essential IPR licensing negotiation. And this general practice is not challenged. Nevertheless, ETSI expects its members, as well as non-ETSI members, to engage in an impartial and honest essential IPR licensing negotiation process for FRAN terms and conditions. So again, we say that that's an important piece of the jigsaw, that the premise underlying this is that the parties will negotiate. And as we know, many licences, indeed probably most of the licences, are negotiated commercially.
But the third subparagraph recognises that the parties might not be able to agree after these friendly processes and for the national courts to resolve the dispute.
My lady, yes, and we entirely accept that. So they may not. There is no, if I can put it this way, there is no ETSI dispute resolution mechanism. Perhaps there should be, but there isn't. And so it's really up to national courts. And as you know, and as you'll have seen, national courts take different approaches to this type of issue. Now, let me take you, please, to the Supreme Court in Unwired Planet, to the parts of the Supreme Court that consider those provisions. And we're in the Joint Authorities bundle behind tab 16. And if we could start at paragraph 7, which is on page 584. And that simply, paragraph 7 on page 584, it summarises the purpose of the IPR policy, of the ETSI IPR policy, as being the twofold purpose that I sought to myself summarise. And then we see paragraph 8 explaining what it is. It's a contractual document governed by French law. It requires an IPR holder whose invention appears to be an essential IPR to give an irrevocable undertaking to grant a licence on FRAN terms. And it's an obligation which third-party implementers can enforce against the IPR holder. Falls to be construed like other contracts in French law by reference to the language used in the relevant contractual clauses, and also by having regard to the context. In this case, that context is both the external context and the internal context of the IPR policy document itself, such as the policy objectives declared in the document. And then you see at 9 that the external context includes the guidance, which I took you to paras 4.3 and 4.4 of the guidance. And then at paragraph 10, the policy, you see that clause 3, which you've seen, provides the internal context, or provides some of the internal context. And then you see the first 3.1, or relevant part of it, set out. And if you go over the page next to letter B, that statement clearly reveals a policy of preventing the owner of a SEP from holding up the implementation of the standard. but that policy is to be balanced by the next sentence of clause 3.1, which speaks of seeking a balance when achieving that objective between the needs of standardisation for public use in the field of telecommunications and the rights of IPRs. The importance of protecting the rights of IPRs is declared in the second policy objective in 3.2, and then you see that set out. And then you see an explanation of how that seeks to address the mischief of holding out, by which implementers in the period during which the IPR policy requires SEP owners not to enforce their patent rights by seeking injunctive relief, in the expectation that licence terms will be negotiated and agreed, and I emphasise those words. So that, going back to the negotiation, if I can put it this way, premise of EPSI, the Supreme Court's there recognising it. So there's a period of time during which it's expected that licence terms will be negotiated and agreed, and in which the SEP owner can't simply apply for an injunction. But then that there might be knowing infringement of the IPRs by using inventions in products while failing to agree a licence for their use on FRAN terms, in circumstances where it may well be difficult for the SEP owner to enforce its rights after the event. Implementers might use their economic strength to avoid paying anything to the owner. They may unduly drag out the process of licence negotiation and thereby put the owner to additional cost and effectively force the owner to accept a lower royalty rate than is fair. So that's looking at holdout generally, and you have my point already that we're not, that the mischief that the judge was looking at when construing clause 6.1 is not that sort of holdout, delaying, dragging heels during negotiations. It's this very specific point about the risk that the implementer might walk away after the determination of FRAN terms, and moreover, the risk during that specific period of time that arises because of the way that the English courts organise their procedure. Now, looking just, I think also, please, if I'd ask you to look at paragraph 14 at the bottom of page 586, the next page. And there, the Supreme Court draws certain conclusions from its review of the IPR policy. And the first conclusion is that the contractual modifications to the general law of patents are designed to achieve a fair balance between the interests of SEP owners and implementers. Secondly, the SEP owner's undertaking, which the implementer can enforce to grant a licence to an implementer on FRAN terms, is a contractual derogation from a SEP owner's right under the general law to obtain an injunction to prevent infringement of its patent. So that's the way that it operates in terms of legal principle. So under the general law, a SEP owner, once there's been an infringement, can seek an injunction, and this represents a contractual derogation from that position. Thirdly, the obtaining of undertakings from SEP owners will often occur at a time when the relevant standard is being devised and before anyone may know whether the patent in question is in fact essential or may become essential as the standard is developed, in the sense that it would be impossible to implement the standard without making use of the patent, and B, whether the patent itself is valid. Fourthly, the only way in which an implementer can avoid infringing a SEP when implementing a standard, and thereby exposing itself to the legal remedies available to the SEP owner under the general law of the jurisdiction governing the relevant patent rights, is to request a licence from the SEP owner by enforcing that contractual obligation on the SEP owner. Fifthly, there's a point about affiliates, which I don't need to read out. And then finally, the IPR policy, and we emphasise this point, the IPR policy envisages that the SEP owner and the implementer will negotiate a licence on FRAN terms. It gives those parties the responsibility to resolve any disputes as to the validity of particular patents by agreement or by recourse to national courts for determination. So the Supreme Court is there saying that what is envisaged, at least in the first instance, is a negotiation. Of course, we say an effective negotiation. And then just on that point, for present purposes, if you could turn to page 598. This is the last part of paragraph 62 at the top of page 598, between the letters B and C. Moreover, the IPR policy envisages that the parties will first seek to agree FRAN terms for themselves without any need to go to court. An established commercial practice in the market is an obvious practical yardstick which they can use in their negotiation. So again, that's we emphasise that part of the Supreme Court's judgment. So that's what I wanted to say for present purposes about the ETSI IPR policy and the guide. I want to take you now to Huawei and ZTE, which is behind the next tab, tab 17. And I want to start with the Advocate General's opinion. And if we, first of all, go to page 634 of the bundle, the Advocate General explains the context in which the request for a preliminary ruling was made at paragraphs 3 to 7 over the page. And so this is page 634, bottom of the page. And you see at the left-hand side, AG3. And so you see that the context is a dispute between Huawei on the one hand and ZTE on the other hand. And Huawei was seeking an injunction, brought an action seeking an injunction prohibiting the continuation of infringement of its SEPs by ZTE. And if you turn over the page, you see that at paragraph 6 that the negotiations broke down. Huawei brought its action for an infringement, for an injunction, and ZTE said that that action constituted an abuse of a dominant position, since it said ZTE, the implementer, was willing to negotiate a licence. And then at 7, the conduct of SEP holders who have given a commitment to grant licences to third parties on FRAN terms has given rise to a plethora of actions before the courts of several member states and third countries, and there's uncertainty as to the lawfulness, the Advocate General says, of certain forms of conduct on the part of SEP holders and undertakings which use the teaching of a SEP, so implementers. And that's the subject of this reference. And then if we turn in the body of the opinion to page 648, perhaps if we start at 647, you see at paragraph 61, the Advocate General saying that the right to bring a prohibitory injunction in the event of an infringement can't just by itself constitute an abuse of a dominant position, because that is the means in which patent holders assert their right. So that's the starting point, but it's not the finishing point, and that's the critical point in this case. And you see at paragraph 63 that it's not an absolute right. The intellectual property right is not an absolute right. And then at the top of page 648, the right to bring actions for a prohibitory injunction is not an absolute and an inviolable right, and must be reconciled with the rules on competition laid down in particular in Articles 101 and 102. So there's a balance to be achieved. And then moving on to page 650 and paragraph 71, the Advocate General is there saying that Huawei's notification of the patent to ETSI and its commitment to license it had an impact on the standardisation procedure and the content of the LTE standard itself. So the notification and its acceptance of the undertaking resulted in its IPR being incorporated in the standard. The fact that the teaching...
Actually, it's the other way around. I mean, it doesn't matter, but actually that's backwards. What actually happens is that the technical proposal is put forward. It's incorporated within the standard if agreed to, and the patentee is obliged to declare it essential, and then you get the ETSI undertaking as a result. So actually, what the Advocate General says is the wrong way round, but it doesn't matter.
My Lord, thank you for that clarification. And my Lord will also, of course, be aware that there are provisions in ETSI that I haven't taken you to, which deal with the position where the declaration is not made, and so workarounds are found,
yeah,
and the patent is not incorporated into the standard. But really the key point the Advocate General is making at paragraph 61 is that whichever way round one looks at it, and I'm really not going to dispute the way you put it, my lord, is whichever way round one looks at it, the fact that this is a set, and the fact that a licence to use the patent is therefore indispensable, creates a relationship of interdependence between the set holder and the undertaking. And that technological dependence, he says, leads to economic dependence. And that's one of the important contextual features, which then led the court to say that in this area, the position is not simply, as under general patent law, that the patentee can seek an injunction whenever they think there's been an infringement, because there's a special responsibility that comes from the fact that implementers have to practice, have to work the patent, the SEP. And that, of course, is something which confers benefits on the SEP owner. And so you then see that there's a possibility, this is paragraph 74, that it might be the case that the SEP owner, fortified by this relationship of economic dependence, uses unfair and unreasonable means vis-a-vis the implementer. And you see that, that where an implementer has shown itself to be objectively ready, willing and able to conclude a licensing agreement, the bringing of an action for an injunction constitutes recourse to a method different from those governing normal competition, to use the words which are used consistently by the courts when describing conduct which is abusive, conduct which has having recourse to methods different from those governing normal competition. And it has an adverse effect on competition, in particular to the detriment of consumers and undertakings which have invested in the preparation, adoption and application of the standard, and must be regarded as an abuse of a dominant position. I'm now over the page. And then at 75, it's clear that such a finding of abuse of a dominant position in the context of standardisation and the commitment to licence a SEP on FRAN terms can be made only after the conduct not only of the SEP holder, but also if the infringer has been examined. And then you have an application of those principles, of that underlying principle, to this case. And the next paragraph I want to take you to is paragraph 80. So to the extent that the infringer is and remains able to conclude and comply with a licensing agreement on FRAN terms, and in particular to pay an appropriate royalty, the SEP holder must, given the importance of what's at stake, take certain specific steps before bringing an action for prohibitory injunction in order to honour its commitment and discharge its special responsibility under Article 102. And then at 181, this is particularly indispensable where it's not certain that the SEP infringer necessarily knows that it's using the teaching of a patent that's both valid and essential to a standard. And he goes on to explain how many patents have been notified then in respect of the LTE standard, and says a large proportion of those may not be valid or essential. And so he says at 82, it's therefore possible that even a large telecommunications undertaking such as ZTE was unable to verify in advance whether all the patents relating to the LTE standard which were notified were essential and valid. It should also be taken into consideration that the telecommunications sector is constantly evolving, and that undertakings and therefore potential infringers must respond quickly in order to bring their products and services to market. It does not therefore seem unreasonable to me that an agreement to license a SEP on FRAN terms should be negotiated and concluded ex post, that is to say, after the use of the teaching protected by that patent has begun. So just pausing there, one of the ways in which the competition law, the operation of competition law in this specific SEP context changes the general approach of patent law is that even where patents are being infringed, currently being infringed, it's still not permissible for the SEP owner to seek an injunction without complying with certain requirements. So even where there is an extant infringement that's been established, And so that's why, just going back to the question my lord put to me in relation to paragraph 288 of the judge's judgment, where I said, well, look, this indicates why the judge, a place where the judge didn't properly take account of these constraints. That's a case in point. So the judge's position was, well, there's an infringement, you need a licence now, and the way to achieve that is to give this commitment, to call for the licence now and take it. And we say, no, that's not what Huawei and ZTE provides. That's not the basis on which it proceeds, not what the court says, and indeed the Advocate General, as you can see. And then you see at paragraph 83, he asks the question, on that basis, what specific steps must the SEP holder take before bringing an action for a prohibitory injunction in order not to be deemed to be abusing its dominant position? And the first point at paragraph 84, and we'll see all this reflected in the judgment, is that unless it's established that the alleged infringer is fully aware of the infringement, the SEP holder must alert it to that fact in writing, giving reasons and specifying the SEP concerned and the way in which it's been infringed. That's the first point. Then secondly, this is paragraph 85, the SEP holder must in any event present to the alleged infringer a written offer for a licence on FRAN terms that contains all the terms normally included in a licence in the sector in question, in particular the precise amount of the royalty and the way in which that amount is calculated. And then you have an explanation underlying that requirement at paragraph 86. He says that that requirement is not disproportionate, as the SEP holder has voluntarily undertaken to secure a return on its intellectual property in this manner, thus voluntarily restricting the way in which it exercises its exclusive right. It's therefore reasonable to expect it to prepare and draft such an offer immediately upon obtaining its patent and giving its commitment to grant licences on FRAN terms. Moreover, given that the commitment from the SEP holder includes an obligation not to discriminate between licensees, the SEP holder alone has the information necessary for the purposes of complying with that obligation, particularly if it's already granted other licences. And then the Advocate General turns to the obligations on the infringer. And so he says at 88 that the infringer must respond in a diligent and serious manner to the offer made by the SEP holder. If it doesn't accept that offer, it must promptly submit to the SEP holder in writing a reasonable counteroffer relating to the clauses with which it disagrees. As the referring court has pointed out, the bringing of an action for a prohibitory injunction would not constitute an abuse of a dominant position if the infringer's conduct were purely tactical and or dilatory and or not serious. And so what you see here is a recognition that competition law is also seeking to achieve the same balance, the same type of balance that the ETSI-IPR policy itself is seeking to achieve. So there are obligations which attach to the SEP owner, with which the SEP owner must comply, and if it doesn't comply with those obligations, it can't claim an injunction, or rather its claim for an injunction would be abusive. But equally, it's recognised that the implementer may be trying to drag things out, and that wouldn't be fair. It wouldn't be fair in those circumstances to deprive the SEP owner of their right to obtain injunctive relief. So that's how competition law addresses the balance of these factors. And then you see at 89 that the time frame, so what's a delay and what's not a delay, must be assessed in light of the facts of the case, and in particular, the commercial opportunity available to the SEP holder for securing a return on its patent in the sector in question. And then it's for the referring court to verify on the facts whether the conduct of Huawei and ZTE is in keeping with those guidelines. And then just looking at I think we should turn now to the court's judgment. So that shows you how the Advocate General approached it. And essentially the court took you to the Advocate General because it's, as is usually the case, a little more discursive than the court's judgment. But the court adopted the Advocate. There's nothing inconsistent between the opinion and the court's judgment. So the judgment starts on page 656. And I think, given that I've shown you the background, and I know you'll be very familiar with this case, let's go to 663. And let me just show you, first of all, paragraph 44, where the court as it often does, combines most of the questions and formulates them into its own question. So all that work by the National Court to draft very precise questions comes to this. So, so by questions 1 to 4 and part of question 5, which questions it's appropriate to examine together, the referring court asks essentially in what circumstances the bringing of an action for infringement by an undertaking in a dominant position and holding a set, which was given an undertaking to the standardisation body to grant licences to third parties on FRAND terms, seeking an injunction prohibiting the infringement or seeking the recall of products, is to be regarded as constituting an abuse contrary to Article 102. So that's the question that it's looking at. In what circumstances will it be abusive for a SEP owner to seek an injunction for infringement of its patent? And then on the next page, at paragraphs 49 to 51, you have you have the court there addressing the question why the SEP context is important. And you see there the point at 49 about economic dependence that the Advocate General referred to. So it's the fact that the patent issue is essential renders its use indispensable. And then 50, that feature distinguishes SEPs from patents that are not essential to a standard and which normally allow third parties to manufacture competing products without recourse to the patent concerned. And then you see at 51 that the other distinguishing factor is, of course, the SEP owner's irrevocable undertaking which they've made to the standardisation body in question. So those are the key features, distinguishing features of SEP cases. And then you see at 55 that in order to prevent an action for an injunction being regarded as abusive, the proprietor of a STEP must comply with conditions which seek to ensure a fair balance between the interests concerned. And then at 56, and this is a point that the Supreme Court, and indeed the Court of Appeal in Unwired Planet emphasised, due account must be taken of the specific legal and factual circumstances in the case. So it's a fact-dependent question. And then skipping on to 59, so 58 makes the starting point that the IPR holder may not be deprived of the right to have recourse to legal proceedings. And then 59, thus, although the irrevocable undertaking to grant licences on FRAND terms given to the standardisation body by the proprietor of a SEP cannot negate the substance of the rights guaranteed to that proprietor by those provisions of the Charter, it does nonetheless justify the imposition on that proprietor of an obligation to comply with specific requirements when bringing actions against alleged infringers for a prohibitory injunction or for the recall of products. And so they have to comply with specific requirements if they're to bring an injunction. And then at 60, accordingly, the proprietor of a SEP, which considers that that SEP is the subject of an infringement, cannot, without infringing Article 102, bring an action for a prohibitory injunction against the alleged infringer without notice or prior consultation, even if the SEP has already been used by the alleged infringer. So just as the Advocate General proceeded on the basis that these requirements that the court is addressing, these requirements on the SEP owner, bite even where there is an infringement that's already taken place, so does the court proceed on that basis. And you see from 60, as the Advocate General found, the first requirement is the requirement to give notice. And you see that also at paragraph 61. And the reason for it, there's a reference back to into paragraph 62 to point 81 of the Advocate General's opinion, which explained why that was important. Excuse me. Then at paragraph 63, secondly, after the alleged infringer has expressed its willingness to conclude a licensing agreement on FRAND terms, it's for the proprietor of the SEP to present to that alleged infringer a specific written offer for a licence on FRAND terms in accordance with the undertaking given to the standardisation body, specifying in particular the amount of the royalty and the way in which that royalty is to be calculated. So that's what the SEP owner needs to do. And of course, just looking at 63, after the alleged infringer has expressed its willingness to conclude a licensing agreement on FRAND terms, it must be assumed in this case that Apple did express its willingness to conclude a license on FRAND terms and indeed made a FRAND offer during the course of negotiations. Then at 60, and then you see at 64, again a reference back to the Advocate General's opinion, explaining why the SEP owner can be expected to make such an offer. And essentially one of the key points is that they're best placed to ensure that they're complying with the FRAND obligation, in particular non-discrimination. And then you see, you then turn to the obligations on the alleged infringer. So by contrast, it's for the alleged infringer diligently to respond to that offer in accordance with recognised commercial practices in the field and in good faith, a point which must be established on the basis of objective factors and which implies in particular that there are no delaying tactics. And again, we say that the judge correctly held that Apple has to be assumed to have complied with that requirement, to have done its bit. And then at 66, should the alleged infringer not accept the offer made to it, it may rely on the abusive nature of an action as a defence to an injunction only if it has submitted a FRAND counteroffer promptly. And so again, that's to protect the SEP owner. So if the SEP owner has played its part and given notice and made the FRAND offer, and if the implementer is then engaging in holdout by delaying, well then at that point there's no defence to an injunction. And then at paragraph 67, further, again this addresses the point where there's already an infringement. Where the alleged infringer is using the teachings of the SEP before a licensing agreement has been concluded, it is for that alleged infringer, from the point at which its counteroffer is rejected, to provide appropriate security in accordance with recognised commercial practices in the field. For example, by providing a bank guarantee or by placing the amounts necessary on deposit. The calculation of that security must include, inter alia, the number of the past acts of use of the SEP, and the alleged infringer must be able to render an account in respect of those acts of use. Now again, that's something which Apple did in this case. So it complied with this. And that is, we say, an important point, because what you see here is a divergence between what the judge below did, what he held, and with what the court is saying happens in a competition compliant negotiation. So here, Apple's offer was rejected. What happens next? Well, what happens next is that to protect the SEP owner, Apple, the implementer, needs to provide security. Well, Apple did that. What happens next is not that the offer is rejected and the SEP owner is allowed to go straight to court to seek an injunction. That's not the position under Huawei and ZTE. And then we see at 68, where no agreement is reached on the details of the FRAND terms following the counteroffer by the alleged infringer, the parties may by common agreement request that the amount of the royalty be determined by an independent third party by decision without delay. Now again, by common agreement. And so it may well be that the parties agree, for example, to arbitrate, or agree that a particular court should determine the FRAND licence. But here there was no agreement. What happened was that Optis jumped the gun, it has to be assumed, and brought its claim for an injunction without doing any of the things it was supposed to do under Huawei and ZTE, despite Apple complying with that judgment. Now, I'd like to turn back to, and then again, sorry, that the answer to the question is in paragraph 71, and essentially I'm not going to read it out, it's quite lengthy, but the court effectively, as it normally does, compresses all of its reasoning into a single paragraph, which is then repeated in the operative part at the end of the judgment. So I'd like to turn back to Unwired Planet in the Supreme Court to see what it says about Huawei and ZTE. So we're behind tab 16. And could you please turn to page 621? It's towards the end of that tab. And at the bottom of page 621, you see under the heading Discussion 149, in our view, Mr. Justice Burse and the Court of Appeal interpreted the CJU's decision in Huawei and ZTE correctly. 150, this deals with the notice point. So bringing an action for a prohibitory injunction without notice or prior consultation with the alleged infringer will amount to an infringement of Article 102, as para 60 of the CJU's judgment sets out. In that paragraph, the language used is absolute. The SEP owner cannot bring the action without infringing that article. So that relates to the notice and consultation requirement. And then the court says that they agree with Mr. Justice Burse's memoirs and with the Court of Appeal that the nature of the notice and consultation that's required is fact sensitive, must depend on the facts of the case. And then the court turns to what is said about the other requirements. And we see from paragraphs 152 to 154, the court there reaches the conclusion that the other requirements, so after notice, what's required next, so the offer and the counter-offer, that those are not prescriptive requirements that need faithfully to be followed in every case, but they are indicators of what conduct will be abusive and what won't be abusive. And that's what the court, in common with Mr. Justice Burse and the Court of Appeal, finds between paragraphs 152 and 154. So in other words, those requirements provide a safe harbour, so if the parties comply with those requirements, there won't be an abuse. But it can't be said that if they don't comply, there necessarily will be an abuse. That will depend on the facts of each case. It's a fact-sensitive assessment that the court will have to determine. And then over the page, at paragraph 155 to 156, the Supreme Court turns to the European Commission's communication, which reinforced its conclusion on the proper interpretation of the court's judgment. And we see there how the European Commission approaches the policy objectives of ETSI that we've seen in paragraph 3 of the ETSI IPR policy. And what it says is that it summarises the conflicting considerations which operate in relation to injunctive relief in SEP cases, saying that such relief aims to protect SEP holders against infringers unwilling to conclude a licence on FRAND terms. At the same time, safeguards are needed against the risk that good faith technology users threatened with an injunction accept licensing terms that are not FRAND, or in the worst case, are not able to market their products. Holdout. And so then you see at 3.1 of the communication, the Commission set out its understanding of the court's judgment in Huawei and ZTE. And it says that SEP holders may not seek injunctions against users willing to enter into a licence on FRAND terms. And the CJU established behavioural criteria to assess when a potential licensee can be considered willing to enter into such a licence. Then going on to paragraph 157, the following paragraphs consider further the various elements in the negotiation, but make clear that what precisely is required is, in the Commission's view, dependent on the facts of the individual case. This coincides with the interpretation we would adopt of the CJU's decision. As the Commission points out, the objective is to protect both the intellectual property rights of SEP owners and the interests of what it calls good faith technology users. The scheme set up by the CJU, as we would interpret it, does this. It prevents an organisation which is unwittingly using a SEP without a licence from being ambushed by injunction proceedings without any prior notification of the problem, provides the SEP owner with a route map which, if it follows precisely, will ensure it can seek an injunction without risking infringing Article 102, and otherwise provides a number of points of reference to assist in assessing the all-important question of whether each of the parties is willing to enter into a licence on FRAND terms. Interpreted in this way, it has sufficient flexibility built into it to cater for the inevitable variations that will occur from case to case and from country to country. And then at 158, given that we share Mr Justice Burse's interpretation of the judgment, we see no reason to interfere with his assessment that Unwired had not behaved abusively. So he found that sufficient notice was given to Huawei. He properly evaluated the course of the negotiations between the parties in light of what the CJU had said. There was no mandatory requirement that Unwired itself make an offer of terms which coincided with those that were ultimately determined by the court to be FRAND. Apart from the more general points we've made earlier, in rejecting the argument that the CJU scheme was mandatory, such an absolute requirement to hit the target precisely with an offer could not sit easily alongside paragraph 68 of the court's judgment, which contemplates determination of the amount of the royalty by an independent third party. What mattered on the facts of this case was that Unwired had shown itself willing to license Huawei on whatever terms the court determined were FRAND, whereas Huawei, in contrast, had only been prepared to take a licence with a scope determined by it. And again, you have my point that Huawei's position in that case was very different to Apple's position in the present case. Until shortly before trial, I'll give you the references because I think that the court's well aware of these points, but until shortly before trial, Huawei had said that it was willing to only to accept a patent by patent licence. That's at paragraph 689 of Mr Justice Burse's judgment. And just before the trial, Huawei said it would accept a UK portfolio licence. That's paragraph 700 and 702 of Mr Justice Burse's judgment. But throughout the litigation, it insisted a global licence would not be FRAND and would indeed be unlawful as being in breach of the competition rules. So that is why Mr Justice Burse and the Court of Appeal and the Supreme Court were able to say that that Huawei's position was that it was only prepared to take a licence with a scope determined by it. That isn't Apple's position.
Well, I'm sorry, why not?
Because
it is your client's position. You are unwilling to undertake to take a licence on whatever terms the court determines to be FRAND. That's why you're here. That's the undertaking you were required by the judge to give, which you're currently appealing against.
My Lord, no, with respect. So we are here because my client is unwilling to commit in advance to taking the licence that the court determines to be FRAND without seeing.
That's what I've just said. What's the difference between what you've said and what I said?
Because, my Lord, what I apprehended you said is that my client is unwilling to take whatever licence the court determines. And it's not. The overwhelming likelihood is that it will take the licence that the court determines to be FRAND. It just won't, it doesn't want to commit to do that before seeing what the terms are. And my Lord, that is the key difference in this case. That's the key distinction. And so we are, with respect, my client is in a very different position to Huawei because Huawei, the Supreme Court was correct to say it was only willing to take a licence with a scope determined by it. The scope being a UK portfolio licence, which even that, it only belatedly, just before trial, agreed was appropriate. So all the way through those proceedings, that was the point of the proceedings. That's why it got to the Supreme Court. One of the reasons was that Huawei's position was that a global portfolio licence would not be FRAND and would be unlawful.
And so the difference on your case between Huawei's position and Apple's position is that Huawei wanted to determine the scope of the licence, and you want to reserve your position in relation to the royalty.
My lady, there are two differences. There are two differences. So one difference is that Huawei was only prepared to take a licence with a particular scope, so a UK portfolio licence. So Apple is not saying...
No, I said that. I said, no, you're not doing that, but your stumbling block is you want to wait and see what the royalty is.
That's correct.
Yes.
And my lady, so I accept that point. The other difference, key difference between my client's position and Huawei, is that it must be assumed that my client made a global brand offer for the license. Now, Huawei never did that because it was contending all through that during the negotiations, its stance was that a patent by patent license was appropriate. So it never made a brand offer. Its offers were confined to that position.
But as we've just discovered by looking at the authorities, the assessment of conduct is very fact sensitive.
It is.
Yeah.
It is fact sensitive. And one of our key points in this appeal is that the judge's construction of clause 6.1 does not permit that fact sensitive assessment properly to take place, because what he's doing is saying that in every case where the implementer doesn't commit in advance to take the court-determined licence, wants to see its terms first, that shows that that shows that they're not a beneficiary of the FRAND undertaking. They're not seeking a licence, and so that the judge's approach, with respect, doesn't permit this fact-sensitive assessment to take place. So a fact-sensitive assessment, what it would look like in our submission, and it's one that couldn't properly be undertaken at Trial F without the facts being determined of what actually did take place in the negotiations. A fact-sensitive assessment would look fully at the conduct of both parties, and if it were the case, if it's the case, as must be assumed, that Apple did its bit in terms of a constructive negotiation and made a FRAND offer, and that, as again must be assumed, what Optis did was not engage with that, deliberately torpedoed the negotiations and applied for an injunction, a final injunction, you'll recall, that's what they wanted, a permanent injunction, in order, again this must be assumed, to try to exact supra-FRAND very high royalty rates. None of that matters, according to the judge, because of this one end point, which is that the implementer, against that backdrop, has not committed in advance to the licence terms set by the court without seeing them. And we say that's the antithesis of a fact-specific assessment. What the judge is doing is he's reading a hard-edged requirement into clause 6.1, which removes any fact-sensitive assessment once this one fact, which is a fact, once this one fact, the refusal to give this commitment, which is a fact very much tied to the way in which the English procedure works, once that one fact emerges, doesn't matter what happens, that's it. The implementer's unwilling, and that's what we say the error is. So we rely on the fact that this is a fact-sensitive assessment. Mr. Pickford reminds me that the other key distinction with Huawei is that Huawei, of course, refused the concrete FRAND licence on the table. So there had been, in that case, a concrete offer that had been made for a FRAND licence, which Huawei refused. Now, in this case, what has to be assumed is that there has been no licence offer made, no FRAND licence offer made. So, my ladies, my lord, just now I'm going to try and distill my submissions on grounds 1 and 2, and I anticipate I can take it quickly. I should know the answer to this practical question, but I'm not sure because we've got a transcript whether we need, do you know whether we need to give a break to the transcriber or whether I just plough on?
We've had no such request.
Thank you. Now, the starting point for interpreting clause 6.1 is common ground. The ETSI IPR policy is governed by French law, and the relevant principles are set out at paragraph 136 of the judgment below. So that's, again, tab 13 of the core bundle, page 158.
Reading the skeletons, the only principle of French law that I could see that either party relied upon was the principle of good faith that you mentioned earlier. Am I correct?
Yes, I mean, yes and no, my lord, in the sense that there was a protracted debate about whether or not you could impose...
No, on the appeal. Of course there was a debate in the court below, but I said reading the skeleton arguments for this court, the only principle of French law that either party relies upon that I've discerned is the principle of good faith.
I apologise, that is correct, my lord,
Yeah.
yes. So, the relevant principles are set out at paragraph 136 of the court's judgment. Could I just ask you briefly to remind yourself of what the judge said? There's no challenge to this part of his judgment. And if you turn to page 178 of the core bundle, you'll see at paragraph 260 at the top of the page that the judge found that clause 6.1 is open to interpretation as a matter of French law. And so he goes on to interpret it. Again, that's not challenged. So what then follows is his construction of clause 6.1 in light of its language and in light of its context. And now to turn to the key steps in the judge's reasoning. And starting on page 181 at paragraph 278, this is the starting point for the judge's reasoning. So he says that the right interpretation of clause 6.1 is that any person interested in implementing an ETSI standard must be entitled to have a licence on FRAN terms on demand to a patentee which is given the relevant undertaking. That is the class of beneficiaries, and it's a very broad one. It's consistent with the ETSI regime of making standards widely available that there should be no restriction in terms of what the beneficiary wants to do commercially as to manufacture, sales or the like, the acts which in the absence of a licence would be an infringement. And so we say that this starting point is correct, so the judge is right to say that the class of beneficiaries is a broad one, and any person interested in implementing an ETSI standard is entitled to have a licence on demand. Then he goes on, we say, to narrow that class of beneficiary, and we see this starting at 279. However, what such a person must be entitled to is to have and take a licence and to operate under a licence. Clause 6.1 doesn't change the position that a party without a licence may potentially be injuncted. Thus, I essentially accept Optis's point that it's not right and not the intention of clause 6.1 for a party using the technology of a SEP to have the benefit of the patentee's FRAND undertaking in terms of immunity from being sued without the corresponding burden of taking a licence. And that, he then, that's a stepping stone. That's really the reasoning that he uses to reach the conclusion he reaches at 285 over the page. So between those two paragraphs is a toing and froing, if I can put it that way, about our respective arguments. And then at 285, one gets to the nub of the judge's reasoning, and he builds on what he said at paragraph 279 that we just looked at, in order to interpret clause 6.1. So he says, so I would express the class of beneficiaries of the stipulation of clause 6.1 as any undertaking which wants a licence to work a relevant standard by any commercial activities and which intends to work the standard under a licence from the SEP owner. Now, pausing there, that's uncontroversial, and we say that Apple complies with this. It does want a licence to work the relevant standard, and it is intending to work the standard under a licence. That's why it's engaged, that's why it made a FRAND offer, and that's why it's engaged in this litigation. And you have my point, you have those points, I've made those points already, but we say that Apple, no basis to say that Apple doesn't comply with that. Then see how the judge interprets this. So he says that this meets the balance envisaged by the ETSI IPR policy because it places no limitation at all on access to the standards other than the need to respect FRAND terms. And then he says this, whether or not this might be fact sensitive in some cases, it is not in the present case, since Apple intends, unless the court stops it, to work without a licence for a period from now until trial E. And so he's saying that the intention of Apple, now of course Apple intends, first of all let me just make that clear, of course inevitably because the parties haven't reached agreement and because they're embroiled in litigation, Apple does intend, doesn't want to, but it intends, it knows that it's going to be working without a licence for a period from between now and trial E. So that is correct. But that does not mean, cannot mean, we say, that under clause 6.1, Apple is not seeking a licence. Yet that seems to be what the judge is saying. That is what the judge is saying on the plain wording of that paragraph. So he seems to be saying, Mr. Justice Meade there seems to be saying that this alone, the fact that Apple now intends to be working without a licence until trial E is enough. That means this alone, he says that this alone means that Apple can be injuncted. And we say that that's completely inconsistent with Huawei and ZTE, as we've seen. And indeed, it's inconsistent with a position whereby, think of it this way, let's say that there are negotiations going on and Apple makes a FRAND, or the implementer makes a FRAND offer which is not accepted, and then the SEP owner makes a counteroffer which again is not accepted. At that point, it can't be said, well, the guillotine comes down because the implementer is already working the standard and therefore they're not willing because they're intending to work the standard until a licence has been set. And yet that's the implication of the judge's judgment. He then goes on to say...
Well, except the key difference is that in this case there's been a court finding upheld by the Court of Appeal that the patent in question is valid and essential and infringed. That was not the scenario under discussion in Huawei and ZTE.
My Lord, yes, that's a difference. But of course, Huawei and ZTE, 2 points, if I may. So Huawei and ZTE specifically, the court specifically held that even where there is an extant and ongoing infringement, these requirements bite. And the Advocate General explained why he held that, and the court also held the same. And I showed you the passages in the court's judgment. So,
if you say that there is a passage in either the Advocate General's opinion or the court's judgment where they address the scenario where the patent has been found by a court to be valid, essential and infringed, please direct our attention to it.
My Lord, there isn't a passage which says that where the court says specifically that there's been a court finding.
Exactly, because the scenario they were considering was prior to the court decision.
My Lord, I disagree with that point, and that's why I showed you. Can I just go back to the judgment? Because, can I, before we go back to it?
You just accepted that they don't address the scenario that I'm putting to you.
My Lord, can you give me the opportunity just to try and address your question? So, I accept that they do not specifically address the position where there has been a court finding of infringement. But my answer to your question, my Lord, is that that is not a material point, because what the court does do in Huawei and ZTE is address the position where there is an infringement. So whether or not there's been a court finding to that effect. And one can envisage a situation, for example, so going back to my analogy with negotiations, one can envisage a situation where the portfolio owner, let's say it's an Ericsson, for example, and it's clear that there are at least some valid and essential patents in the portfolio. And the negotiation is going on, and the implementer says, well, it's clear that we're infringing, because we do accept that there are at least some patents in your portfolio that are valid and essential. So we don't need to go to court in order to work that out, but we do need to negotiate a price. So there's no need for a court determination, because it's common ground that there's an infringement in this scenario, in this hypothetical scenario. And what happens next in the negotiation is that the implementer makes a FRAND offer, an offer in the FRAND range, and the SEP owner says, no, I don't like that, we want something higher than that. makes a counteroffer, and let's say, as negotiations often evolve, the implementer thinks, well, that's not going to accept that because that's too high. I think we can do more in this negotiation to reach agreement. Well, on the judge's view, so on what the judge says in paragraph 285, at that point, the implementer, when it hasn't accepted, there's no agreement that's been reached, it's common ground that they're infringing, the implementer is intending to operate the standard until such time as licence terms are available and agreed. But that does not mean that the SEP owner is entitled to go to court and seek an injunction, and that would be contrary to Huawei and ZTE. And my lord, just to go back to Huawei and ZTE, so we're in the joint authorities behind tab 17.
Yeah, well, we just have been through this at great length.
My lord, I know, but I'm addressing my lord's question, and I can do it quite quickly. So if we go to page 664, paragraph 54, you can see there that the refusal may in principle be raised in defence to actions for a prohibitory injunction. So what's contemplated here is that the other elements of the cause of action are made out. There has been an infringement, but what may be raised in defence is the separate point about compliance with the steps that the court is requiring. And then you see at 67 on page 666, and again I'm repeating myself, but furthermore, where the alleged infringer is using the teachings of the SEP before a licensing agreement has been concluded, it's for that alleged infringer to protect the position of the SEP owner by providing security. So all of this is premise. You're right, my lord, that they don't say, oh well, in this case there has been a court making the finding of infringement. But they do assume that there is an infringement, and it's on that basis that these steps nonetheless bite.
Well, except that they keep saying the alleged infringer. So the premise is that the infringement hasn't yet been established objectively. At least in that passage in paragraph 67, you may be able to show me something else.
My lord, yes, my lady, I'm so sorry. Yes, it does refer to alleged infringer, but really, going back to paragraph 54, the assumption there has to be that there is an infringement, because otherwise you wouldn't have a defence to an injunction. You wouldn't get to that. You wouldn't be at that point of having to raise a defence to an injunction that was otherwise well-founded. It must be well-founded. You only need the defence because there is an infringement. And so the basis on which all this proceeds is, my Lord Justice Arnold is correct to say that on the facts of this case, there's not a court judgment that could be pointed to saying that there's an infringement. But nonetheless, it proceeds on the basis that these steps are required even when there is an infringement. And so that's why we say that the judge's reading of clause 6.1 at page 285 is wrong, because what he's doing is saying, well, as soon as you have this finding of infringement, the guillotine comes down, and the SEP owner is entitled at that stage to an injunction. He says that's not a fact-sensitive question.
Well, he's not quite saying that, is he? Because he's saying the reason that the SEP owner is entitled to the injunction is because there isn't an unqualified commitment by Apple to take a licence on FRAND terms.
My lady, there's a can I unpick that a little bit?
Yes, of course.
So what he's saying is he is concerned. I think it's important to look actually at some of the paragraphs I skipped over. So if you look at paragraph 283, the judge is there confronting the submission that we made below, that we make again before this court, that it's not correct, it wouldn't be right to construe 6.1 in a way which is UK-centric, if I can put it that way, to summarise the point that I made at greater length earlier. And so he says, I do, however, accept that there's some force in the criticism made by Apple that Optis's formulation of the class of beneficiaries, the need for a commitment, and its arguments generally have been framed too much in the specific context of UK proceedings, with too much of an eye to the period which elapses in UK practice between a finding of infringement of a valid patent and a Fran trial. But I don't think that matters much. The key concept and key argument for Optis was the one I mentioned before, the implementer not having the burden of the Fran undertaking, not having the benefit of the Fran undertaking without accepting the burden. So the judge is there, just pausing. He's there saying, he's there acknowledging the force of our argument, if I can put it that way, about not interpreting clause 6.1 in a way that specifically addresses this problem. And he sees then, if you look at 286, he says not expressing the analysis in terms of giving a commitment avoids the problem of the interpretation being too tied to UK procedure. So he's trying to arrive at a general interpretation of 6.1, which doesn't refer to commitments at all, because he recognises that that's too tied to the UK procedure. But with respect, he doesn't accomplish the task that he's set himself, because going back to paragraph 285, his attempt to interpret or to construe 6.1 in a way which doesn't refer to commitments or is not targeting that particular specific issue it proves too much, because he says whether or not this might be sensitive in some cases, it's not in the present case, since Apple intends, unless the court stops it, to work without a licence for a period from now till trial. And really, taken literally, that is inconsistent with Huawei and ZTE. And it's inconsistent. It just doesn't work, because you go back to my analogy about applying that principle. So he's construing 6.1 in a general way. And if that were the right construction, how does that apply to negotiations? So again, just going back to the point I made about negotiations, what if there's a constructive, let's assume a constructive negotiation between the parties, but the implementer, who's already working the standard, doesn't accept the offer on the table in the expectation that the negotiation will proceed constructively? Well, at that point in time, they are obviously intending to work the standard until such time as they can agree a licence without a licence in place. And so the words that the judge uses there are, though that condition is met, that general condition, but it obviously isn't right that at that stage, the SEP owner would be able to say, well, let's stop this constructive negotiation, we're going to court and we're seeking an injunction now. That would obviously be inconsistent with what the court said in Huawei and ZTE and with the policy, the ETSI policy of encouraging negotiations. So in his attempt to avoid tying this too closely to the commitment issue, he's arrived at a construction which proves too much. He then says, it will also not be fact sensitive in any case where the implementer declines to commit to a licence on Fran terms, but wants to work the technology of a patent that it's been found to be infringed. And again, not only does that not achieve his goal in the immediately following paragraph of not tying the interpretation down to the UK procedure, but it also proves too much, because it avoids, eliminates the possibility for any fact-sensitive assessment of the type that Huawei and ZTE compels.
But in the paragraphs you're criticising, the judge is applying his construction to the particular facts. So he's already decided at a broad general level how he should construe clause 6.1, and in these paragraphs, I mean, it seems to me that he's applying that construction to the particular facts in front of him.
Well, Eddie, I agree with you, but then one asks. So I agree that that's how this is how this is formulated. But then the next question that follows in my respectful submission from what my lady's just said is this: well, what is his general construction of clause 6.1? So if it's not the specific, you can see why, standing back, one can see why you can't get out of clause 6.1 a specific obligation on the implementer to accept, to commit to a court-determined licence. You simply can't read that into clause 6.1. And the judge recognises that, and recognises that that would be too UK-centric an approach. Yeah. And so you're right, my lady, I agree with you that what he's doing here is he's interpreting clause 6.1 generally and then applying it to the facts of this case. But then one has to ask, and this is really the critical point, well, what is his general construction of clause 6.1? And the general construction of clause 6.1 is that it is found in the first part of the paragraph before he applies the definition to the facts. And he says that a person, the class of beneficiaries, a person who wants a licence and intends to work the standard. Now, if we were to stop there, as I say, we don't dispute that that is an appropriate interpretation of clause 6.1, but the key point is, what does he mean by intends to work the standard under a licence from the SEP owner? This is really getting to the heart of it. And what he means, you can then see where he applies this to the facts. He says, it's not fact sensitive here because Apple intends to work without a licence for a period from now until trialee. And so what he's saying is Apple doesn't have a licence now, and it's intending to operate without a licence for this interim period. Ergo, it's not intending to take a licence. And so his construction of clause 6.1, and in particular his view of what's meant by intending to take a licence, we say goes too far.
And presumably you say that sentence cannot be read with the next one, where he says that it will also not be fact sensitive where the implementer declines to commit to a licence, because he's already mentioned that the need for commitment perhaps is a bit English-centric.
Yes.
But he has, at 283, said the key concept is they can't have the benefit without the burden. And isn't that what he's doing, in fact, in the whole of 285?
My lady, yes, so we'd agree with that. And what he's really doing, so he's said that this is not an Anglo-centric or UK-centric interpretation, but he has, in fact, in expressing the position in, to start with, quite reasonably uncontentious terms, he's then revealed what he means by those rather general words. And what he means is, if you are at any particular point infringing and you don't have a licence, that means you're not intending to take a licence. And if you are at any particular point infringing and you haven't given the commitment, that means you're not intending to take the licence. And we say, no, that's wrong, because the question of whether you're seeking a licence, which again, just coming back to the wording of clause 6.1, it's seeking a licence. So he's already glossing those words by talking about intending a licence, intending to take a licence. But leaving that aside, coming back to the wording of clause 6.1, whether you're seeking a licence has to be a fact-sensitive question. That's what the Supreme Court has held.
But he's saying, interpreting the phrase seeking a licence, they're not seeking a licence in this during this period because they're not prepared to enter into a commitment to accept a FRAND licence as determined by the court.
Paragraph 290.
He is. So that's what he's saying. So he's saying that you're not intending, and that we say that's far too narrow a reading or an application of the concept of intending to take a licence. And there is no basis for it in clause 6.1. Because what clause 6.1 requires is an assessment in the round of whether the implementer is seeking a licence, including by the application of the French law principle of good faith. And what the judge is saying is, well, in this specific circumstance, where never mind what you've done up to this point and how willing you've shown yourself to be, the SEP owner goes to court, seeks an injunction and asks you to sign up to that court-determined licence without seeing its terms. If you refuse to do that, you're unwilling.
Yeah, that's what he's saying.
That's what he's saying. And we say that that's really the nub of the error, that he there is essentially finding that that's the only way that you can demonstrate that you are willing. Doesn't matter what else you've done, how constructively you've engaged in the negotiations, how many FRAND offers you've made, how unreasonably the SEP owner has behaved in refusing your FRAND offer. So as I said at the outset, take a position where the implementer has made a FRAND offer, which is perhaps midway in the FRAND range, so they're a very realistic implementer. And the SEP owner says, no, we think we can do better if we go to court. And so they don't engage in the negotiations. In fact, they scupper the negotiations. They don't exchange any of the type of information you would expect to see exchanged in a negotiation, which would help the parties arrive at an agreement. They go straight to court, so they don't do anything. They don't take any of the steps that Huawei and ZTE refers to. They go straight to court and say, right, we're going to give you the license that the court determines at the end of the day. If you don't commit now to take it, you are unwilling. And we say that that is far too narrow a construction of clause 6.1. And what it does is it usurps the role for the French law principle of good faith, which does require a fact-specific analysis. He's saying that this one fact means that no other facts are relevant. And we say that both the French law principle of good faith, which is the overlay for clause 6.1, and competition law, as Huawei and ZTE have established and as the Supreme Court has held, say that this is quintessentially a fact-sensitive exercise, and it can't be right, we say, that one fact is the killer fact.
Were there any negotiations after the finding of infringement?
So, were there in fact any negotiations in this case after the finding of infringement? Can I take instructions? It's a rather complicated question because there's also a without prejudice element to all of this. Yeah. So, can I take instructions before I come back?
I just got the impression from the judgment that there weren't. So there was a period where there were attempted negotiations which failed. There's then litigation, there's a finding of infringement, and the judge is concerned with the period between the finding of infringement and the determination of the FRAND terms by the court. Is that right, or have I got the wrong end of the stick?
So, my lady, he is concerned with. Sorry, do you mean concerned with the period between? Do you mind repeating what you said?
No, well, it wasn't a very. I'm sorry, it's my fault. It's not a very clear question. My impression from reading the judgment is that there were negotiations which failed for whatever reason, and you say because Optis were being obstructive and so on. There was litigation. There was a finding of infringement, and the focus of his reasoning is the period between the finding of infringement and the time when the FRAND terms are determined by the court. Is that right, or have I got the wrong end of the stick?
No, my lady, that's right in the sense that. So I think where he gets into that is in relation to the competition law ground, and so what he says is that this goes to the point he makes about. We have a separate argument, as you've seen, which is even if we're wrong on construction.
I understand that.
And I think that in dealing with that argument, what the judge says is that he refuses, he rejects our case under competition law on the basis that whatever happened in the negotiations, let's assume it all in Apple's favour, that the abuse has ceased to have effect once the litigation started. Yeah. So I'll address that in relation to the competition law point. But in a nutshell, my lady, we say that that certainly can't be assumed, and that in a sense that what the judge did, the key flaw in his judgment at that stage, was to jump the gun and prejudge the issue, because that can't be assumed until all the facts are found. But just one more point on the final sentence of paragraph 285, where he says it won't be fact sensitive in any case where the implementer declines to commit to a licence on FRAND terms, but wants to work the technology of a patent that it's been found to be infringed. There are, of course, lots of different factual patterns that can lead to that situation. So that's also a fair description of the position at the end of that Mr. Justice Burse, as he then was confronting in the Unwired Planet Remedies judgment, because at that stage, the FRAND terms had been settled, and the implementer had declined to commit to the licence because it wanted to appeal, and it wanted to work the technology of the patent it had been found to have been infringed. And of course, that situation is very different, we would say, to the current situation, because the terms of the licence were known. And we don't quibble with on that. So if there were, so where the facts are as in Huawei and ZTE, then we can see that on the facts, where there's a licence there to be taken and the implementer declines to commit to it, but wants to work the technology despite declining to commit to this licence, that an injunction may well be appropriate and is unlikely, highly unlikely to conflict with Huawei and ZTE. But this case is different because there is no licence there to be taken. And we say it must be assumed that a key reason why there's no licence there to be taken is because of Optis's obstructive behaviour. And so that's a very different fact pattern. And the fact that one can envisages these different fact patterns leading to the same conclusion, which is encapsulated by the final sentence of paragraph 285, we say makes our point for us, because what both Huawei and ZTE, what competition law requires, but also the French law principle of good faith requires, is indeed an analysis of those facts in order to determine whether or not the implementer is not willing. So
I think we've got your point that basically you're saying it can't be a one-size-fits-all. That
exactly.
can't be a factor which always sways the balance.
My lady, yes, it's not a trump card in every case. And then what you have at paragraph 288, just in terms of following through the judge's reasoning, is, and we've looked at this already, he says that there's a simpler way of looking at things. And again, and I made this point at the outset, so I'm not going to flog it now, but what he's saying is that the moment at which Apple is found to be infringing is the moment where it ceases to be a willing licensee if it's not committing to this court-determined licence. And again, he just says that follows as a matter of patent law. And again, our key point is that fails to properly take account of the constraints that apply where a patent is set. And so, just to make our first, to distill our first submission on the wording of clause 6.1 is that we say that the construction that the judge has arrived at doesn't find any support in the language of clause 6.1, which imposes obligations on the SEC owner and isn't directed to imposing obligations on the implementer at all. And the reference to seeking a licence, which we accept the implementer must be doing in good faith, can't be read to incorporate such a hard-edged requirement.
So are you submitting that the judge was wrong to hold that clause 6.1 imposes implied obligations on the implementer?
We're not challenging that he's finding that we're not challenging this appeal. He's finding that
I'm just trying to understand the submission. So you accept that clause 6.1 does impose some kind of an implied obligation, do you?
We accept that as a matter of French law, what was in dispute was whether, as a matter of French law, it's permissible in this kind of stipulation to impose a burden on the third party.
Right.
And so for the purposes of this appeal, we're accepting his finding that as a matter of French law, it's not impermissible. So one of the arguments we ran below was to say, well, look, this is impermissible as a matter of French law. So we're not running that point now.
Right.
But what we are saying...
Do I infer from the cagey way you're putting it that it might be a point that might be run in a future case?
Well, I don't know.
Maybe I shouldn't ask that question. Delete it from the record. All right. So you're accepting for the purposes of appeal that in short, there could be an implied obligation imposed on the implementer.
As a matter of law.
Yes.
That's not impermissible as a matter of French law.
Right.
But in construing it, one has to look at the language and at the policy objectives.
Yes.
The language is seeking a licence.
Mm.
What the judge has done, we say, is in effect, even though he's disavowed this, is to read in a hard-edged requirement to clause 6.1, which is you're not seeking a licence unless you commit to take a court-determined licence. And we say that there's no basis for reading that in as a matter of language.
And the other way of looking at it is to say he's just applied, he's applied his broad general construction to the facts of this case, and he said on the facts of this case they aren't seeking a licence because in this period after they've been held to have infringed, they won't accept an unqualified commitment to a court-determined FRAN licence.
My lady, yes, and if that is the way that he's approached it, so if he's applied seeking a licence to the facts of this case, we say that he's done that in a way which doesn't take account of all the facts of the case. So he's done it in a way
because you submit that all the stuff about the negotiations, which at the moment, as I understand it, predated the finding of infringement, is relevant to the question of whether or not you're seeking a licence.
Yes, but, so what we say is that what Huawei and ZTE says is that in order to determine whether seeking an injunction is abusive, one has to look in a fact-sensitive way.
I grasp that, yeah. Okay.
And my lady, just on that point, if you look at paragraph 277 of the judgment, page 181, the judge says that the approach Apple takes, so it's the IC approach, that's the term informed consent approach that the economists were using. But he says that essentially our argument would provide a tool which could be used by implementers if they so decided to carry out or support holdout. And so we're saying that there he's recognising that the fact that a commercial entity wants to see the terms of a global licence before finally committing to them doesn't necessarily mean that they are practising holdout. So he's recognised that. He says they could be used to do that, but
yes, but the fact that it's a tool that could be used to support holdout may be relevant to his approach.
Well, my lady, we say that that reinforces our point about fact sensitivity, because it may be clear on the facts of any particular case that the overwhelming likelihood is that it wouldn't be used as a tool, or it couldn't be used as a tool for holdout. So take facts. I mean, let's imagine, for example, that you have an implementer such as Apple, which is not isn't subject to the same financial constraints that, say, a startup or a new market entrant might be subject to. And let's say that, as in this case, there are ongoing and parallel proceedings in the courts of other states because the SEP owner has sued in parallel in other states. Then the court might well take the view, applying a fact-sensitive approach, that the opportunity for holdout in a case such as that is minuscule or non-existent, because because the likelihood of the implementer not accepting the court-determined licence is very small, but B, because if they did, there would be another way there would be another way, ready-made way of achieving the global terms, because there's litigation going on in parallel in other courts. And so it is a fact-sensitive question. And what we say the judge has done here is said, well, because it's a tool which could in principle be used by implementers, I'm going to say that in all cases where there's not a commitment to take a court-determined licence, the implementer's not seeking a licence, not intending to operate under a licence, and that we say is the...
Well, but has he said that's what clause 6.1 means, or has he said, when I apply clause 6.1 to these facts, that's what I find?
Well, the necessary consequence...
I mean, we're going back over the ground we've already covered in this.
But my lady, just briefly, in answer to your question, the necessary consequence of his finding is that it's always the case, because, of course, the facts haven't been determined here. They all have to be assumed in Apple's favour. And so what he's saying is there are no facts that could emerge on trial which would cause me to change my mind. And you see that later on when
this is
says,
about the abuse of dominant position argument.
I'm so sorry?
This is about the abuse of dominant position argument.
No, it's about the question of whether or not the correct interpretation, the correct application of the term seeking a licence.
Right.
So it's both. So that the term seeking a licence requires interpretation, requires application in each case.
No, I understand that, but your essential point is the judge has ignored here all the points you were making about the negotiations that preceded the finding of infringement.
Yes.
Okay.
And just to kind of position that in terms of the legal analysis, that is important for two reasons. One, because of competition law, which my lady has said, but also just as a matter of construction of clause 6.1, which is subject to the overlay of the principle of good faith, and which itself requires a fact-sensitive analysis of whether someone is seeking a licence.
But I should perhaps have corrected that question, because, of course, the judge assumed all those facts in your favour.
He assumed all the facts in our favour, and so the upshot is that whatever the facts, this one trump card means that you can't be seeking a licence for the purposes.
Yeah. Okay.
And then you can see at 289. Yes, Mr. Pickford makes the point, sorry, I'm repeating myself, but at the end of 285, directly in relation to my lady's point, he says it will not be fact sensitive in any case where the implementer declines to commit to a licence. So he's excluding any.
Well, hold on, but he's very much anchoring it in these facts, isn't he? Saying that any case where the implementer declines to commit, but wants to work the technology of a patent that it has been found to infringe.
Yes, but what he's saying is the very fact of the failure to commit to a court-determined licence by itself, and regardless of any other facts, is the trump card. It's what makes someone...
If you've been found to be infringing.
Yes.
Yeah, that is what he's saying.
Yes, that's what he's saying, and we say that is the error, because
All right.
the reason why we say it's the error, and again, I'm sorry if I'm repeating myself, I'm sure I am, is because Huawei and ZTE proceeds on the basis that there may well be an infringement, but these steps are still required. I mean, so ETSI is a derogation from the general position under patent law, and equally competition law changes the general position under patent law, such that there may well be an ongoing infringement, but it's not permissible for the SEP owner simply to seek an injunction. They have to take certain steps, and so there has to be a fact-sensitive assessment. But what the judge is saying, and this is where we say he's gone wrong, is that, as my lady put it, or rather as you haven't put it, but I'm paraphrasing my lady's point, the guillotine comes down once there's been, the guillotine comes down once there's been a finding of infringement, and that's that, if you don't give the court the commitment.
Okay. Well, that's been very helpful, because I now understand your argument.
Thank you, my lady. Whether you agree with it is, of course, a different question. But if I've conveyed it, then that's I'm doing my job. The next point I wanted to make is that, and this is really the second point. So the first point relates to the language of clause 6.1. The second point is that the judge has paid lip service only to the importance of negotiations. And of course, the reason why this point is important is that his interpretation of clause 6.1 needs to be robust to all possible factual circumstances. And he correctly recognised, if we go back to the judgment, if we go to page 132, first of all, in paragraph 78, he correctly recognises, he's here repeating, you'll recall the fifth conclusion of the Supreme Court at paragraph 14 of the Supreme Court's judgment that I took you to, is that the ETSI IPR policy envisages that the SEP owner and the implementer will negotiate towards a licence on FRAN terms. This is significant to the argument about the use of dominance by Optis. Apple asserts that Optis prevented meaningful negotiations. We see at the end, one of Optis's answers is that negotiation is not to be regarded as beneficial in itself. The fifth conclusion runs counter to that submission. FRAN negotiation is extremely important, which Huawei and ZTE makes clear as I review below. And then if you turn to page 188, paragraph 314, this is in the context of the competition, the discussion on competition law. And the judge is here determining an argument made by Optis. So Optis said, oh, well, it can't be a breach, it can't be abusive, even if you assume all these facts against us. So even if we did make exorbitant offers and we disrupted the negotiations, that can't be abusive if we subsequently go to court and say we're going to offer a court-determined licence. And the judge rejected that, and he says that the negotiation step in relation to SEPs, the subject of FRAND undertakings, is on the authority of the Supreme Court of substantive importance. It provides the implementer with an opportunity to persuade the SEP owner and to avoid costly and wasteful litigation, and it provides a means by which the implementer can obtain information about the SEP owner's portfolio and comparable licences. By those means, the implementer has the ability to try to hold any terms which are agreed to ones which are reasonable. A SEP owner's refusal to negotiate at all could therefore increase the pressure of threatened litigation and might lead to the implementer agreeing in ignorance to pay royalties which were too high or out of line with what other licensees were paying. If a refusal to negotiate at all could be an abuse or a contributing factor to a broader abuse, then it must follow that rendering negotiations meaningless by asking for exorbitant terms can be as well. So the judge is correctly finding there that an abusive approach to negotiations by the SEP owner isn't neutralised, if I can put it that way, by the SEP owner subsequently agreeing to provide a licence on FRAND terms that will be determined by the court. And the judge was right to find that. However, we say that his construction of clause 6.1, and in particular his finding that not giving the commitment means that you're not seeking a licence, that you're not a beneficiary of the ETSI undertaking, would enable the SEP owner to frustrate negotiations or indeed to bypass them altogether. And they could do that by not engaging in the negotiations, acting abusively, and commencing proceedings in the English courts, and then offering for an injunction, and offering to enter into the court-determined licence and demanding the undertaking, and then carrying on the proceedings to a court determination, all the while avoiding further meaningful negotiation with the implementer, which is of course what Apple alleges against Optis in this case. And on the judge's construction of clause 6.1, the past conduct of the SEP owner, and indeed that the implementer, the person seeking a licence, so whether they've made FRAND offers, whether they've behaved constructively, and indeed their conduct in the proceedings, all become irrelevant once a patent's found to be valid and infringed. And so we say that in short what that means is that on the judge's interpretation, clause 6.1 could see judicial determinations of global royalty rates for portfolios of thousands of SEPs. Upon just one of those SEPs being found valid and infringed in the UK, could find that wholly supplants negotiation as the norm and the preferred approach for SEP licences. And that would be inconsistent with the importance of negotiations highlighted in the ETSI IPR policy and emphasised by the Supreme Court, and the fact that the give and take and the flexibility of negotiations can't be replicated in judicial determinations. And it will mean that the implementer has in essence to sign a blank cheque, as they'll not have had access to any of the information and knowledge that they would have gained about the portfolio through a negotiation. And on that point, if I could just ask you to turn up Optis's skeleton argument. So tab 8 of the core bundle, page 75. And paragraph 31. So Optis say here, Apple's suggestion that the commitment to a court-determined licence as the signature of a blank cheque is misguided. It's not a blank cheque, it's a cheque for an amount that the implementer knows will objectively be fair, reasonable and non-discriminatory. But you have my point that FRAND is a range, and it may be that figures towards the top end of that range, even if FRAND are not commercial for the particular implementer at issue. Further, the judge's unchallenged finding of fact was that implementers are able to estimate what a FRAND rate is likely to be. So the commitment is not a blank cheque in any event. And the reference there is to paragraph 227 of the judgment. So if we could please turn that up. So behind tab 13, page 173. And you'll see that the judge says there that the evidence also established, in my view, that implementers are able, with information from research organisations, the EPSI database, and set holders themselves in the course of negotiations, to estimate what a FRAND rate is likely to be. There is, of course, uncertainty, but commitment to a FRAND rate is not writing a blank cheque. So that's his finding. But you'll note that, that he refers there to information from set holders themselves in the course of negotiations. And that, we say, is by far and away the most important source for the implementer of information relating to the valuation of the specific portfolio under consideration. So questions like, what is its technical strength? In other words, how many patents are likely to be valid and essential? And what is its technical merit? So do the patents relate to key innovations, or are they trivial in their impact? And by far and away the most important source of that information is going to come from the negotiation. And a failure by the SEP owner to engage constructively in negotiations means that the implementer will be deprived of valuable information that can help it determine what the royalty rate is likely to be. Now, Apple's case at Trial E is that the negotiations in this case simply did not result in a productive exchange of that nature. And so Apple's case at Trial E, for example, is that in the negotiations, Apple sent Optis detailed technical feedback on the sample of claim charts for Optis's declared SEPs, and that feedback that Apple sent addressed the question of validity and whether the patents were actually essential. And Apple also explained why it considered that the patents in Optis's portfolio were of very limited technical merit. And while there were some technical discussions, Optis never replied in writing or in those discussions to Apple's feedback in relation to the technical merit of its patent. So while Apple would agree that information from SEP holders during negotiations is very important in informing the question of FRAND valuation, it wasn't in this case. And the technical strength and technical merit of Optis's portfolio is still the subject of considerable disagreement at Trial E, and the parties are a very long way apart. So Apple's case is that the difficulty of forming any meaningful estimate about what it might potentially be signing up to if it were to give the commitment is further compounded by the fact that Optis's royalty demands increased over the course of the negotiations. And indeed, the difference between what Optis demanded in the negotiations and what they've claimed now in the litigation can be measured in billions of dollars. And their case has even continued to evolve over the course of the litigation. And so, insofar as the ongoing changes during the litigation are concerned, in its statement of case, which you don't have in front of you, but if you want to, we can produce copies, of its statement of case on FRAND in February 2019, Optis's pleaded case was that the appropriate benchmark royalty rate in relation to 4G devices in major markets was 0.41%. Now, in its original position statement of January 2022, that rate was 0.34%, and in its amended position statement of March 2022, the rate had gone down to 0.22%. But your lordship and your ladyships will have seen footnote 7 to our skeleton argument. Let me just take you to that. So that's behind tab 7 of the core bundle at page 51. So what happened was that despite in the amended position statement the rate being said to be 0.22%, that's March 2022, in its closing submissions at trial, Optis has now raised the suggestion of rates of 0.46 or 0.69%. And so the position is, and you can imagine, given that this is a global portfolio license, what these differences translate into large sums overall. And so Apple's case, which no doubt Optis disputes, but that's not the point. The point is that this needs to be assumed. The question is, could the judge reach the conclusion he did while these points are yet to be determined? Apple's case is that because of the way in which Optis has conducted itself in both the litigation and the negotiation, Apple's position is that this is still very much blank cheque territory. So it's been deprived of the steps that should be taken by the SEP owner to engage constructively in the negotiation, which would have allowed it to have formed a view as to what it might end up paying. And it's being asked to commit to something in circumstances where it can't reach a meaningful view as to what it might be committing to. Now, the third submission, so that's negotiations, and to repeat the point, to summarise the point rather, we say that negotiations are of substantive importance. We see that from the Supreme Court, we see it from the ETSI policy, the guide, and from Huawei and ZTE. And the upshot of the judge's approach is to enable negotiations to be bypassed. The third submission we make is the point that I made at the outset about the jurisdictional balance, the extraterritorial effect. And I'm not going to repeat the submissions I've made. I hope that I conveyed the point that I wanted to convey. But I do just want to take you in that context to the TQ Delta judgment of this court, because it's not the same as what we're saying is going on here, but it's analogous in the sense of a SEP owner trying to leverage the fact that the UK courts do properly set global FRAN rates in order to achieve something which falls the wrong side of the jurisdictional line. And so if we could turn to the joint authorities behind tab 12. And if we start perhaps with a footnote. So there had been a finding of infringement in this case. So I'm on page 285 behind tab 12. So there had been a finding of infringement in this case, and then you see from paragraph 3 of the head note that Zyxel, so at the technical trial, there'd been a finding of validity and essentiality, but the patent was due to expire, and there was then a hearing to determine the form of order and further directions. And Zyxel had announced that they were no longer willing to take a FRAN licence, and so injunctive relief had been granted against them. But then the judge had refused to vacate the forthcoming FRAN trial, and directions had been given for there to be an inquiry as to damages in the same time slot. What you see from paragraph 8 of the head note on 287 is that Mr. Justice Burse held that there continued to be a real and lively dispute as to FRAN terms. This had not gone away and was a real commercial dispute. Further, the RAND issue was well defined, and the suggestion that if the case were to go ahead, effectively Zyxel were only notional respondents stood or fell with the issue of the effect of the waiver. And so essentially he held that the FRAN trial should go ahead as planned, despite Zyxel submitting to an injunction. Now Zyxel appealed, and I just take you to paragraphs 51 to 52 of the judgment of this court, judgment of Lord Justice Floyd. And that's on page 300. And so you see, running through paragraph 51, it's describing there Mr. Saunders' submissions, Mr. Saunders for the SEP owner. Running through Mr. Saunders' submissions was the suggestion that Zyxel could achieve by their strategy of selective country-by-country waiver, a situation in which TQD are forced to sue them on a country-by-country basis. If such a strategy is permissible, he said, it would seriously undermine the approach to RAND licensing of SEPs, which the court in Unwired Planet had explained. I don't agree this is a real concern. The circumstances which made it commercially possible for these Zyxel companies to waive their right to enforce the RAND obligation in the UK are not likely to be commonplace. the patent on which they've lost happened to have only 3 months to run. Companies participating in international telecommunications are unlikely routinely to be in the same position. These considerations force me strongly to the conclusion that the questions on which the court's declaratory relief is sought are far better decided in the foreign court where those questions arise, if they ever do. It would be an exercise in jurisdictional imperialism to voice this court's view as to whether Zyxor were unwilling licensees or holding out on an unknown foreign jurisdiction. Far less can it be said that the interests of justice is in the interest of justice for it to do so. Now, so we rely on this by analogy. So it's another case in which what was being said by the SEP owner was, all right, English courts, you've got the ability and the jurisdiction to set global FRAN terms, and you ought to do so, because this is really the only way, the only forum which, if it's not done this way, then there'll be holdout, because the SEP owner will be forced to chase.
That was in circumstances where the implementer had waived its entitlement to rely upon the ETSI undertaking. I mean, it wasn't an ETSI case, but the equivalent of the ETSI undertaking.
Yes.
And had submitted to the injunction.
That's right, my lord. And so, but what we say is that, and really this goes back to the points I made at the outset, that essentially the position on Mr. Justice Meade's judgment is that an implementer in that position is not able meaningfully to exercise that same choice, because I made all the points at the outset. I don't want to repeat myself, but you have my point, which is that if you're a global operator, then the foundation of the approach of the English courts, and this was in fact how Unwired Planet itself evolved, is that the court sets the FRAN terms, and then the implementer can choose whether to submit to an injunction or to accept those, to enter into the license. That's the choice that the implementer has. And what we have, if Mr. Justice Meade is correct, is a position where that choice is effectively taken away in any meaningful sense, because the implementer is not able to properly choose which of those it wants to do, because it doesn't know the terms of the license. And that's by contrast, as I put it at the outset, to the position of a company, of an implementer that's just operating in the UK, just operating UK SEPs. Because if they were to give the commitment and they found that the licence terms set by the court were uncommercial, they could exercise the choice of not operating in the UK and therefore not paying sums which it found to be uncommercial. But a global operator is unable to do that, so it's deprived of the meaningful choice of submitting, as Zyxor did, to an injunction. Once it's given the undertaking, it no longer has that choice at the end of trial-e. It has to take the global licence, even if it thinks this is uncommercial. And that's why we say that, on that basis too, we say that the judge erred in construing clause 6.1 as he did, because it results in an exorbitant jurisdiction.
Conversely, though, once the FRAN trial has been held and the terms of the FRAN licence have been established, if you think they're okay, you can get the FRAN terms, and you'll no longer be subject to the injunction.
That's right. So that is correct. So that's the consequence of the ETSI undertaking. So we can get the FRAN terms, and a proper choice can be exercised.
So the blanket check argument only really applies to the period between the finding of infringement and the establishment of the FRAN terms.
Yes, and I made that point, my lady, in opening. I think I may have misunderstood. So, my lady, no, I think separately, I think if it may be that I wrongly agreed to something. So, if what my lady's saying is that the blank check is extinguished at the FRAN trial, that's not so. That's why this is exorbitant. So, if you sign up, if you make the commitment in this, once the finding of infringement has happened, which is what the judge envisages, and then the FRAN terms are settled, and the implementer thinks that they're uncommercial, then they're stuck with them. They can't.
No, my point's a different point. My point is that this only really affects the period between the finding of infringement and the establishment of FRAN terms, because if once the FRAN terms are established, you like them, you can then have them, and you won't be subject to the injunction.
But if you say, that's right, but the problem is if you don't like them, then you can't take the choice. You can't make the choice between the injunction and accepting them. And really we say that the proper exercise of that choice is fundamental to the jurisdictional balance, so that the English courts are only in the business of setting global rates in the context of infringing UK patents. And so the choice of any implementer is, do I submit to an injunction on this UK patent, or do I sign up to the licence? And what this precludes is a proper exercise of that choice, because there is no licence on the table. You don't know the terms until they're determined. So what it means is if you give the commitment, you don't have the choice anymore, because after the Fran trial, you have to take the licence, and you can't choose to submit to the
but you do have a choice whether or not to give the commitment.
Yes.
And you know precisely what the consequences of giving and of not giving the commitment are.
Yes, but not the sum.
Yeah.
And that's really the point. So those were my submissions on construction. Unless the court has any questions on construction, I was going to move on to competition law.
Thank you.
So if we could please go back to the judgment, tab 13.
I think before you do so that you've already laid out a lot of the groundwork for this.
I can take it shortly, my
Yeah.
dear. Yes, I will take it shortly. And please do speed me up if you think that I'm not taking it shortly enough, but my notes are quite short on this point. I think I can cut them down even further in light of the discussion we've had. So paragraphs 313 to 315, I've read already. Sorry, I've got the wrong bundle. If you just bear with me for a moment. So it's page 188. And you've seen these, so I'm not going to read them out again. But this is where the judge rejected Optis's argument that the competition, the alleged abuses are somehow extinguished by their offer to give the court-determined licence. And just on paragraph 314, you've seen the judge's reasoning, which is that the abuses could result in increased pressure on the implementer, which might result in it paying royalties which are too high. And remember in this context that Optis's argument was below and is on the cross appeal that the injunction that should be granted is a permanent injunction that would forever exclude Apple from enforcing the undertaking. And think for a moment what that means. If it were right for the court to order a permanent injunction, then Optis could charge whatever royalty it liked, and Apple would have to pay it or submit to an injunction in the UK, which is a huge bargaining chip. We say a huge skewing of the negotiations. Now Optis say, well, that's not right, because we'd still be subject to competition law, which would stop us charging excessive prices. But 3 short points on that. The submission is a rather, if I can put it this way, opportunistic one, because in Trial E, Optis are claiming that they're not dominant and therefore not subject to competition law. But even if they are subject to competition law, even if we're right, the threshold for a price being excessive is above the threshold for FRAND. And what it would mean is that the SEP owner would be able to charge would be able to charge excessive prices. And if the implementer thought that those prices were abusive, it would have to bring a separate action for damages in order to enforce its competition law rights. So in other words, if Optis were right on its cross appeal, you would never get to the FRAN trial. So the judge was clearly right to reject Optis's argument that the competition allegations, if made out, were neutralised by Optis's subsequent offer to provide a licence on court-determined terms. He then went on to consider the implications of this for Optis's application for an injunction. And as you've seen, he found at that stage of the analysis that the abuse had ceased to have effect, and on that basis found that it would be disproportionate to refuse an injunction. And I'd just like to look at his reasoning. So, top of page 189. So paragraph 317, he assumes that Apple will succeed in establishing the abuses alleged, and he reminds himself that he's dealing with the availability of final relief, not the possibility of interim relief on American cyanamide principles. or relief pending an appeal. And then he says at 318 to 319, he refers to the consideration of this issue in Unwired Planet by Mr. Justice Burse, which he says his analysis was overturned, which it was, of course, because he found that there was no abuse on the facts of the case. And he says that the Supreme Court did not have to consider it because it upheld the decision there was no abuse. I do have to decide it. And then Mr. Justice Burse's judgment in Unwired Planet contains pointers both ways, as I've identified above. He made a general statement at paragraph 744, little 7, that usually an injunction should be refused if there has been an abuse, but went on at 795 to say he was far from being convinced that refusal of an injunction would be proportionate. And then he says, Mr. Justice Meade says, I don't consider that those statements are necessarily inconsistent, and he reconciles them. He says that if there is an abuse of dominance, an injunction will be withheld unless the court thinks it's disproportionate to do so. Factors in the assessment will include the following, which are factors which Mr. Justice Burse referred to too. So we, at this stage, agree with the statement of principle in paragraph 320. We don't think there's anything wrong with that. What you've seen from Huawei and ZTE is that if there is an abuse in seeking, in the circumstances in which an injunction is sought, then that can be raised as a defence to an injunction. And so we say that the judge's starting point, which is an injunction should be refused if there's been an abuse, is the right starting point. But that there is then, we accept a proportionality, it's still a discretion, and a proportionality analysis, which takes place to establish whether or not the refusal of an injunction would be proportionate. And we also agree that, as with any proportionality assessment, it's a fact-sensitive, multifactorial assessment. The court will need to look at all relevant circumstances. And so we agree that where the judge says factors will include the following, he's right to use the word include. And the key point that we make is that the question of proportionality, given that it requires all relevant facts to be taken into account, could not be taken properly at trial F, where the facts had not yet been found. But then moving on to the reasoning.
But isn't that concern dealt with by the fact that the judge made assumptions in your favour that the abuse had been established?
My lady, I'm going to come to that.
Okay,
if you
sorry.
don't mind, I can answer you now, but if I can just
No,
deal
no,
with his
please,
reason
you
first, then
do
I'll
it in your...
But I will
in your
address
own
that
order.
point.
All right.
So then going on in the reasoning, he says that although the Supreme Court, this is 321, did not consider the specific issue of grant or refusal of an injunction in the light of a finding of abuse of dominance, I think its analysis of SEPS, the Frand undertaking, and the discretion to award damages in lieu of an injunction are highly relevant by analogy. Its reasoning and conclusions were not available to Mr. Justice Burse, in particular in relation to damages in lieu, which was not argued before him. Then 322, the Supreme Court made a very clear decision that the normal position is there should be an injunction against an infringer. It particularly stressed that that ought to be the case where the infringer has the means to get a licence, as Apple does, but does not take it. Apple's allegations of dominance don't change that fact. And so pausing there, we say that the judge was, with respect, wrong to say that, and sorry, just before I make my submission on it, you see over the page that 324, refusing an injunction will tend to leave the SEP owner with an inadequate remedy. And that is only part of the picture, because there may be positive purposes from withholding an injunction. But I think it means the position has moved on from when Burse gave his judgment in Unwired Planet. And so, just in terms of the legal reasoning, what you see is a starting point based on Mr. Justice Burse's decision, where the starting point is that an injunction will generally be refused where it's been sought abusively, but there is discretion to order it. And then that's reversed by reference to the Supreme Court. And so you then end up in a position at 325 where the judge says things have moved on. And he says also that the normal position, he says at 322, by reference to the Supreme Court, is that there should be an injunction against an infringer. And so we do say that he's reversed the presumption, as it were, and that the...
But doesn't that turn on his reasoning in the last sentence of paragraph 322? He says the allegations on this do not change the fact that it is now able to invoke the obligation, but does not want to.
My lady,
isn't that the hinge of it all?
My lady, yes, and that's the point. I'm going to come to that. That's the point
Right.
I'm going to come to, which is the point he makes about ceasing to have effect, the abuse having ceasing to have effect. It's really the same point.
Yeah.
I will address that. But just on the reasoning at the moment, just pausing there, of course, the Supreme Court, the judge is right to say, was not addressing the position of whether to grant or refuse an injunction in circumstances where there had been an abuse of dominance. So it wasn't confronting the Huawei and ZTE issue because there'd been a finding that there was no abuse. And so what it was doing was proceeding purely on domestic law, on a domestic law basis, where of course the norm is to grant an injunction if there's been an abuse of a patent. And we say the prism through which the judge approached this was wrong. Then at 326, you have really, and this comes back to the point that my lady's has put to me. So what the judge finds here is that he in the middle of 326, he grapples directly with the abuse which comprises the disruption of negotiations and the risk of Apple having been rushed into agreeing excessive royalties without adequate knowledge of Optis's portfolio or basis for its requested rates, and says that too has ceased to have effect. The parties are just too far apart to have settled, but Optis has had to plead out its case on rates to the court's satisfaction, and Apple knows where it stands. I said above that it is necessary to consider the aggregate effect of the assumed abuses, but it doesn't make any difference at this stage. The alleged abuses have no continuing effect separately or in totality. And he then rejects at 327 my argument that if an injunction has been sought abusively, then where the court grants the injunction, it's facilitating the abuse. So that argument was rejected. But turning back to the point about ceasing to have effect, the question, so we say that the question whether it's proportionate to withhold an injunction is a fact-sensitive one, and here all the relevant facts have not been found. And in this case, the determination of the relevant facts have been left over to Trial E, and we make two key points here. So the first point relates to the nature of the abuse. Now, as my lady put it to me, the judge assumed the abuses in Apple's favour, but we say that that isn't the end of the story. And it wasn't sufficient for the judge to take the view that because he was assuming that the competition law allegations were made out, that was all that was possibly relevant in terms of the facts. And that's because the factual findings relating to Optis's conduct, as determined at trial, could well have a bearing on the issue of whether it would be appropriate to withhold an injunction. So, for example, what if there were documents showing that Optis was pursuing deliberately a detailed plan to disrupt the negotiations, to torpedo them, and that its application for an injunction, a permanent injunction, was made in the expectation that this would lead to very high royalties being paid, and it would skew the negotiations, skew the position in its favour. Well, we say that if it were established that this was all a deliberate ploy, and its stance in the litigation was a deliberate ploy to exact higher royalties than it might otherwise achieve, that would plainly be relevant to the multifactorial assessment. Even if you left aside competition law, and you're looking at things from a domestic context and whether or not the applicant for an injunction has come to the court with clean hands, that sort of finding would be relevant. The second point we make relates to what the judge says in the last sentence of paragraph 330. So if you could go back to the judgment. So the judge is at 329 saying what he believes the key factors to be. And then at 3:30, he says, these all militate in Optis's favour, and it'd be wrong to withhold an injunction. One can imagine that in other different situations, it would be appropriate to refuse an injunction, especially if the SEP owner had not committed to adhere to the court's decision on Frand. Another example might be if the SEP owner was seeking an injunction at a time when it had still not explained the basis for the rate sought. And pausing there, he says it's unlikely in the context of UK litigation, but that is our case here. So we say that Optis was seeking an injunction in circumstances where it hadn't explained not only the basis for the rate sought, but the rates that it had put forward were exorbitant and bore no relation to Frand. And you have my point about how those rates have varied wildly during the course of the litigation itself. And so the absence of the type of information that would have been exchanged in a constructive negotiation is likely to have had an impact on the manner in which trial E was litigated. So, for example, if Optis had responded properly to Apple's analysis of the strength of its portfolio, the judge would have had all of that before it, and Apple would have been better equipped to form a view as to its likely liability on the licence. But none of that was available. And what the judge is doing here is reaching a conclusion that he can't properly reach without taking account of the facts as found at trial. The fact that he says Apple knew where it stood is just factually wrong. Now, this point also ties in with our ground 4, which I can take very swiftly. I know that you said you would sit on a little bit.
Maybe not.
What does that mean?
Attention, please. Attention, please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area.
I think we must do
Do
that,
not
and
run.
we will commence again
Do
at 10 o'clock
not
tomorrow.
use the lifts.
All right.
Follow the instructions of fire evacuation.